welcome to the first revision lecture for CA Intercorporate and Other Laws in English language only, specially for students who wish to learn in English. In this video, we are going to discuss a part of the Companies Act, and in the next video, I'm going to complete the revision for the other units of Companies Act. We are going to revise the Companies Act with the help of my chart book, which you can access from my website theorymasterslearning.com. Link is in the description box. If you're watching my video for the first time, I am CA Preeti Aggarwal and I make videos specially for you. Do subscribe to your channel Theory Masters Learning and hit the bell icon so that you get notifications for all the upcoming videos in English only. So students, let's begin. The Companies Act 2013, it extends to the whole of India. It applies to the state of Jammu and Kashmir also. The title, that is the short title, is the Companies Act 2013. Will all these small questions be asked in the exam? No, but this is just a warm-up session for the provisions that we're going to study next. So the Companies Act's short title, this is the short title. It is known as the Companies Act 2013. Section 1 of the Companies Act, it came into force at once, but the remaining sections, they were notified through dates, on different dates through notification. So the entire act did not come into force at once. Various sections came into force in different timelines. This act is applicable to companies, insurance companies, banking companies, companies producing or supplying electricity, companies regulated by special act, and entities as notified by the central government. If you want to know the applicability of this act, if you want to know whether this act applies to my business or not, then the application is given in this act. It applies to all companies. It applies to insurance, banking, electricity company. Sorry. Now, these are companies which have their own act. They are governed by their own statutes. But the Companies Act applies insofar as there is no inconsistency. But if there is inconsistency, meaning the act applicable to electricity or insurance company is saying something, whereas the Companies Act is saying something else, then their respective act, that is the Electricity Act, or the act applicable to the insurance companies, that is the IRDA, that will apply. So their respective statutes prevail. But if there is no inconsistency, both their acts, the statute as well as the Companies Act, is on the same page, then there is no matter of dispute. As soon as there is some inconsistency, then their statutes will prevail. Companies which are regulated by special act, so in this case also they are governed by their own statutes insofar as the inconsistencies are concerned. What is the definition of company? Now, how is company defined? Section 2 clause 20 defines company as: company means a company incorporated under this act or any other previous company law. Now, whenever the word company is used in this act, it does not mean the companies which are incorporated under the 2013 Act only. This act applies to all the companies, whether incorporated under the 2013 Act or previous act, like maybe the 1956 Act or the 1913 Act. You cannot argue that no, I was incorporated in the year 1960. So even today, the Companies Act 1956 applies. Sorry, even though you were incorporated in the earlier act, when the word company is included in this act, it applies to all the companies, whether incorporated under this act or the previous Companies Act. I think it's a very good and a meaningful definition. What are the features of a company? Company means an incorporated association. This is the first characteristic of a company. It is an incorporated association. Association means it is a group of persons who have come together for a common purpose. It has to be incorporated, it has to be formed under law by the operation of law. It doesn't take birth like a natural person. It is clothed with legal personality. It has to be brought into existence by operation of law. So it has to be incorporated. It's an artificial person which is created by law. It is not a natural person. It doesn't take birth like a natural person. It has to be formed, it has to be incorporated under law. It's a person. It means that all the features of a person will apply. It means, like a natural person, a company can file a case, it can enforce the contractual rights and liabilities, it can sue, it can be sued, it can purchase property in its name. So since it's a person, it can perform all the acts like a normal living person. So it's an artificial person. Artificial because it does not take birth like a natural person. It is a person capable of contracting. It is created by law, hence it can be brought to an end also by operation of law. So it doesn't die a natural death, it has to be wound up. It has separate legal status, it's a separate entity. Separate entity means it is a person separate and distinct from law, from the person who has formed it. So members are separate from the company. Company is not liable for act of members. Members are not liable for acts of the company. This is the corporate veil or veil of corporate personality. It has perpetual succession. Members may come, members may go. Members may buy the shares, they may sell the shares. Members may die, they may become insolvent, insane, but the company's existence continues till it is wound up. So there is perpetual succession. It means that the company goes on till it is wound up. The business continues. It is not affected by insolvency, death, insanity of any member. But if you compare it with the other form of businesses like partnership or proprietary, they are affected by death or insolvency, insanity of their members. But here, company is not affected. So this is nothing but perpetual succession. I don't think a question will be asked on those provisions. But yes, very, very important for exam. Classification of company on the basis of members and of a classification is into a one-person company. See, students, if you go through the heading, the classification is on the basis of members, the number of members. In one-person company, we have, tell me, only one member. In case of private company, how many members? We require minimum 2 members to form it. And in case of public company, we require minimum 7 members to form. Yes. Oh, it's not visible. I'm so sorry. I didn't check it. Yes. So in case of a private company, we need minimum 2, and public company, we need minimum 7. All right. So on the basis of members, I'll just shift a little. On the basis of members, it is classified into first a one-person company. Now, what kind of questions can be asked on one-person company? They can ask you a theory question, a case-based question, MCQ, simple MCQ, case-based MCQ. So a variety of questions can be asked on the concept of one-person company. So it is very, very important for exam. Students, if your attempt is in November 22 and you wish to study from good, concise, precise notes for exam, then do visit my website theorymasterslearning.com for the books combo that we have. This combo consists of the main law book, which is the theory, and it also contains relevant questions. The second book that is in the combo is the CA Interlaw Compiler Bomb. It is a question bank covering all the past exam questions, study material, RTP, MTP questions arranged unit wise. In case you have any doubt relating to books, lectures or test series, you can contact me on the number given on the website and also in the description box. All right, students. Now, what is a one-person company? In this, we have minimum 1 member. Okay, so one person acts as a member, and we have minimum 1 director. Okay, so 1 member, and maximum also we have only 1 person. Why not incorporate a private company? Because he wants to do business alone. So it is a very good option for people who wish to do their business alone and they don't want to start a proprietary and unorganized kind of business. Now, what are the legal provisions or the requirements of a one-person company? There is no minimum paid up capital requirement. You can start the OPC like any other company. There is no minimum paid up capital. You can start the company even with minimum 10,000 rupees. Yes, you should bring in at least that much amount of capital as is required for you to pay the fees to maybe your lawyer who is preparing, or the company secretary, or the chartered accountant who is preparing your memorandum and articles of association, helping you in incorporation, some filing fees, some basic goods that we need to purchase, or maybe a machine that you need to buy, or computer. You have to bring in some basic capital at least. So you can bring in 10,000, 5,000, 20,000, your wish. Minimum authorized capital is 1 lakh in case of OPC. Okay, now there is one member, but what if the member dies or he is incapacitated to act in his capacity as a member? He's not capable. Let's say he meets with an accident or goes into coma. Then who will manage the business on his behalf? We have a nominee. Nominee is a person who will manage business on behalf of the member in case the member dies or is personally incapacitated to act. The memorandum will indicate, what will it indicate? Name of the nominee. That is a person who shall, in the event of death or incapacity, become the member of the company. So in case the member dies or becomes incapacitated, nominee will become the member. Nominee's place is empty. Yes, he will nominate some other person as a nominee. This is perpetual succession. Now, there are certain requirements of member as well as nominee. So what is the eligibility in this case? The eligibility requirement is that member and nominee, okay, it applies to both. It should be a natural, they should be a natural person. Natural means living person. Artificial person cannot incorporate one person company. They may be a promoter. The artificial person may incorporate a private or a public company, but not OPC. He must be a citizen of India. Citizenship is given to individuals only, living persons, whether resident in India or not. Okay. Earlier, there was a requirement and resident, he should be a resident. But now, after the amendment, he may or may not be a resident. Even then, they have defined a resident. Now, why? Anyways, even if you are not a resident, you can be a member or you can be a nominee. Then why define it? Since the term resident is used over here, they will have to define it, right? So who is a resident? Resident for OPC means a person who stays in India for at least 120 days during the previous financial year. Is it same for all? No. You have to see the definition of resident considering the act, considering the concept. Like in case of one person company, they have reduced it to 120. But in case of LLP, which you had studied in CA Foundation, resident still means a person who is in India for 182 days. But here, they have reduced it to 120. All right. Now, name should be indicated in the memorandum. Because appointment of nominee is mandatory at the time of registration, you have to write his name and also obtain his consent. Why consent is required? Otherwise, you will name anyone in the as your nominee. So we need some proof, no, that yes, you want to appoint him as a nominee and he has also agreed. So his consent will be filed with ROC. Name will also be written in the memorandum. What if I want to change a nominee? You know, nominee dies, or maybe I fought with a nominee. I want to change. There is some dispute. Nominee can be changed. In that case, member will give notice to the company and the company will give notice to the ROC. Okay. So in this case, member will give notice to the company and company will give notice to the ROC that we have changed the nominee, and also give the name of the new nominee along with his consent. This is again very important, students. No person shall be eligible to incorporate more, where is it? To incorporate or be a nominee. I'll highlight it. You're not eligible to incorporate or be a nominee in more than one OPC. Can I say it means that I cannot be a member in 2 OPCs? I cannot be a nominee in 2 OPCs, but can I be member in 1 OPC? And nominee in another OPC? Yes. Can I be member in one, nominee in another? Yes. I cannot be member in 2, nominee in 2. Minor shall not be, okay, highlight the word not. minor shall not be either a member or nominee of OPC. He's not capable of contracting, cannot be a member or nominee of OPC. Important for exam. Can be asked as MCQ. It cannot be converted or incorporated into a Section 8 company. Section 8 is your non-profit organization. You cannot incorporate a Section 8 company with just one member. You cannot convert OPC into Section 8 company. But it can easily be converted into either private or public company. Earlier, there were restrictions. But now, after the amendment, there is no restriction as to paid up capital turnover. There is no restriction as to the time. You can convert the OPC into either private or public company anytime that you want. OPC cannot carry on non-banking financial activities, including investment in securities of a body corporate. Generally, company is a person separate in the eyes of law, so you can purchase shares of another company. But OPC cannot purchase the shares. They cannot invest in the securities of another company. If you want to buy the securities, then you should buy those securities in the name of that one person. Buy it in his personal name, not in the name of OPC. So with this, we complete OPC. I have covered all the important provisions of one-person company. Next, let us discuss the private company. So private company means a company which is a close-knit company. Yes, minimum 2 members, maximum there is a limit of 200. So restrictions, they are imposed by articles. Whatever restrictions are imposed, they are through the articles. The members are bound only by the restrictions in the articles, not what they have mutually agreed. It prohibits, that is the first restriction, it prohibits the invitation to the public. You cannot offer shares to the public. They go for private placement, rights issue, bonus issue. Right to transfer the shares is restricted. You need the consent of the board. You can't just transfer the shares like a public company to any person of your choice. Maximum number of members is restricted to 200. So these are the 3 restrictions which make a company a private company. If these restrictions are there in the articles, it's a private company. Otherwise, it will be considered just like a public company. All the provisions of a public company will apply. While calculating this maximum number of 200, you will exclude present employees cum members as well as ex-employees cum members. Joint holders will be treated as 1. The company will lose the privilege in case of non-compliance. Now, to summarize all this, there are 3 restrictions which make the company a private company. In those 200 members, you will not include employees because we encourage company to allot shares to employees so that they feel associated with the company. Joint holders will be treated as 1. Company will lose privileges in case of non-compliance. Then what is a public company? Public company means a company which has minimum 7 members. Maximum, there is no limit. Minimum 3 directors. Any company which is not a private company will be a public company. Subsidiary of public is also a public company. Now let's say, for example, I have A Limited and there is a subsidiary B Private Limited. Even though this is a private company, since it is a subsidiary of public company, it will be deemed to be a public company. So does it mean that it has to alter the name? It has to remove those restrictions from the articles, reduce the number of members to 200? No, it need not do anything. Only thing is that the privileges of a private company will not apply. It will be considered just like a public company. So it is not a private company. The articles do not have restrictions. Shares are freely transferable. Minimum you need 7 members. Maximum there is no limit. Maximum number of members there is no limit. Minimum there are 3 directors. Private subsidiary of a public company is deemed to be a public company. Okay. Then there is classification on the basis of liability, wherein the company can be classified as a company limited by shares, company limited by guarantee. We can even have an unlimited liability company. Company limited by shares. In this, the liability of members is restricted to, tell me, the amount unpaid on shares. So if the shares are of face value 10 and I have paid 6 rupees, now my liability is only 4 rupees. You cannot expect the members to give you anything more than 4 rupees. So here the liability is limited by the memorandum. Why is memorandum written over here? Because one of the clauses of memorandum is liability clause. There you will have to mention whether the company's liability is limited. If yes, whether it is limited by shares or guarantee, or is it unlimited liability company. So it is limited by memorandum to the amount, if any is written, because it is not always possible that you will have some amount unpaid. It can be that you have collected the entire 10 rupees at the time of application only. So if there is any unpaid value, that is the only liability of members. They will not contribute anything from their personal assets. In case of company limited by guarantee, the liability of members is restricted to the amount of guarantee which they will pay at the time of winding up. Now, this is mostly a company which does not require money during the lifetime, because they get a lot of money through endowments, fees, charges, like a Section 8 company, or a company which does not require a lot of working capital during the lifetime. They need money at the time of winding up. So they ask the members, will you help us during winding up? Members say yes. So we go to X, he promises to pay 10,000 rupees. We go to Y, he says I will pay 15,000. We go to Z, he said I will pay 2 lakh. We ask them, promise, will you pay? They say yes, guaranteed, we will pay money. Such type of companies are known as guarantee companies, wherein members, they promise to give the money at the time of winding up. But that's not compulsory. You may have a guarantee company with share capital, or you may have a guarantee company without share capital. In case of a guarantee company with share capital, you have two liabilities. One is the amount unpaid on shares, which you can claim anytime during the lifetime of the company. And the second liability is the amount of guarantee which the members will give at the time of winding up. In case of company not having share capital, then in that case, your liability is only one, which is guarantee that you will have to pay at the time of winding up. Okay, so the liability of members is limited by the memorandum to the amount guaranteed by the members to contribute to the assets of the company, that also in the event of winding up. So in case of guarantee company, your liability arises in case of winding up if you don't have share capital. Members cannot be called up to contribute beyond that stipulated sum which they have guaranteed. What is an unlimited liability company? Unlimited liability, as the name suggests, there is no limit to the liability. Then why incorporate a company? You could have gone for a proprietary or a partnership business. But there are other benefits also, no? Separate legal status. And in case of unlimited liability company, the liability is not always unlimited. During the lifetime, they get to enjoy limited liability, but it is only unlimited as far as the creditors are concerned, which they will enforce at the time of winding up. So I don't think that the company will wind up so soon. And even if it does, we'll see later. At least during the lifetime, I get to enjoy limited liability. Important for exam, definition is important, can be asked as a case-based question. What is a foreign company? See, whether a company is a domestic or a foreign company, it depends on the place of incorporation. If the company is incorporated in India, even though all members are foreigners, it is still considered as a domestic company. But if the company is incorporated outside India, then it is considered as a foreign company, even though all the members are Indians. So you have to see whether it is a domestic or a foreign company based on the place of incorporation. Any company or body corporate, you will highlight incorporated outside India. The word outside is important. So if you are a company which is incorporated outside India, then you are a foreign company. But why study that in our Indian Companies Act? Because you are doing business in India. So even though you're a foreign company incorporated outside India, but because you're doing business in India, the Indian Companies Act will apply, all the rules will apply. You cannot argue that because I am incorporated outside India, the Companies Act does not apply. See, if you're doing business in India, if you have presence in India, whether physically or electronically, then the act will apply. Any company or a body corporate which is incorporated outside India, it has a place of business in India, whether by itself or through agent, either physically or through electronic mode, then, and it conducts business activity in India, then it is considered as a foreign company. There are certain provisions which will apply. So if you're doing business in India, either by yourself or through agent, you're physically present, you have a shop or a factory or a warehouse, or you are doing trading, you have some electronic presence like social media, SMS, email, or telemarketing, then you are a foreign company, but the Companies Act will apply. Holding and subsidiary, important for exam. In the May 22 RTP, they had asked a question on listed company in combination with holding and subsidiary. So both the concepts were tested in one question. I have uploaded a detailed discussion video. I'm leaving a link over here, students. Please go and watch that video, RTP discussion, and it is in combination. Okay, both these concepts are asked together. According to me, a question can be expected on listed company because there are amendments, and no question has been asked on listed company till now. You can expect a question. A direct question will be asked, but you need to know the definition properly. What is a holding company? The act doesn't define a holding company properly. They say I am a holding if you are my subsidiary. So I need to define a subsidiary company properly. Let's see how a company is defined. A holding company under section 2 clause 46. Holding company in relation to one or other companies means the company of which other is subsidiary. So if you are my subsidiary, I am automatically a holding. How is a subsidiary defined? According to section 2 clause 87, subsidiary means a company in which the holding controls the composition of the board of directors. How will control the composition of the board? Controlling composition of the board means I can either appoint or remove all or majority directors of subsidiary without the consent of any person at my own discretion. So if the company H can either appoint or remove all or majority directors of S, then H is considered as the holding company of S. It exercises or controls more than one half of the total voting power. Either on its own means H owns 60% in S. It owns so much capital that it has more than 50% of the voting power. H is the holding of S, or together with one or more subsidiaries. H plus its subsidiary S both jointly own 70% in S1. S1 is the subsidiary of H indirectly. Yes. So in this case, it owns either on its own or together with one or more of its subsidiaries. There is one more case which you should know. H controls 60% of S and S controls 70% of S1. So here also S1 is the subsidiary of H. So you control either directly or together with one or more subsidiaries, or your subsidiary controls some other company, then that is also your subsidiary. So these relations are very important, especially this one. If you remember the format that I have given you, you will never go wrong. Okay, H, S and S1. Along with this, we have another concept of associate company. Now, who is an associate company? Earlier, we had only the concept of holding and subsidiary. But to become a subsidiary company, you need to own at least 50% of the total voting power. But what if B Limited, it controls 30% of the voting power or business decisions of A? Now, A is not yet a subsidiary company because B is not holding more than 50% of the voting power. But B is holding some significant amount at least, so that it can influence the decisions of A. So why not create some separate relation? So that brought into the concept of associate company. So here, because there is an associate, there is a relation, transactions will be considered as related party transactions. Directors, if they are common, they are not independent. Auditors, if they are common in both these companies, they are not independent. So some kind of relation is now established. We are monitoring the transactions between these two companies, because even though you don't own more than half, you own at least some significant portion. Now, what is the meaning of significant? In relation to another company, associate means a company in which that other company, okay, associate means a company in which that other company has significant influence. Now, what is the meaning of significant influence? Now, B controls minimum 20%. So I need minimum 20%, but which is not a subsidiary, means less than 50%. So if you are controlling 20 to 50%, or I should say 49%, so if you're controlling around 20 to 49%, then you will be considered as an associate company. Okay. So you are no longer, you're not yet a subsidiary, but we have significant influence over you. It includes a joint venture company or a joint arrangement. Now, joint venture has the same meaning which you have studied in 12th standard. So A and B, they both do business together in a joint venture. They are known as associate companies. Yes. So yes, we need to know the definition of associate. Then we have a listed company. Listed company means a company whose shares are listed on the stock exchange. I have done a detailed discussion of the definition in the RTP, so I'm not repeating it again. Unlisted company means a company which is not a listed company. Then we have other types of companies like government company. Government company means a company in which either central or state, one or more states, or both central as well as one or more state governments owns more than 51%. So at least 51. It's not 50%, students. At least 51. Why am I stressing on that? Because a question, case-based question can be asked on this. They will give you various governments like central government, state government. They will give you the holding. You have to calculate whether the company in which they have invested is a government company or not. So let's say, for example, that A has investments from central government, one or more state governments, central plus state governments. So in that case, if they hold at least 51%, not even 50%, but at least 51% of the paid up capital, then it will be considered as a government company. So at least 51 is held either by the central government, one or more state governments, partly by central, partly by state governments, then it is a government company. It also includes subsidiary of such government company. So let's say that A Limited is a government company. P Limited is its subsidiary. This subsidiary will also be considered as a government company. All the provisions of a government company shall apply. Then most important, I think OPC and Section 8 company, super important. Very, very important for exam, formation of company with charitable objects, Section 8. It is a company whose aim is not to earn profit. So does it mean that they don't earn profit? No, they do, but they don't aim to earn profit. The transactions which they do, it's not with the intention of earning profit. Whatever profit they earn, if they earn, that will be utilized not for distribution in the form of dividend to members, but it will be used for the company itself. So these companies are formed for promotion of commerce, art, science, culture, education, religion, protection of environment, sports, etc. So this is the first thing that you should write in your answer. It uses the profit for the promotion of objects for which it is formed. So they don't use the money for distribution in the form of dividend. They do it to promote the objects. This is the second point which you should write in your answer. Then it does not declare dividend to members. In fact, it is prohibited from declaring dividend to members. So these are the 3 points which should be present in your answer, come what may. Even if they ask you a theory question or a case-based question on Section 8 company, you should compulsorily write these 3 provisions. It is compulsory. It operates under a special license. Now, why so? See, whenever I am a Section 8 company, I'm working for the society, I get certain privileges because my aim is not to earn profit. Now, I can't one day say that I am entitled to all the privileges. I am a Section 8 company. You have to apply to the central government. They will give you the benefit of a Section 8 company. They will give you certain privileges, and that privilege, that permission to obtain to function as a Section 8 company is given through license. So we need a special license from the central government wherein they are authorizing us to claim all the privileges of a Section 8 company. No need. This is one of the privilege. Now you may ask me, ma'am, what are the privileges? No need to use the word limited or private limited at the end of the name. A partnership firm is not a separate person in the eyes of law. They cannot be a member in company. But in Section 8 company, you can have a partnership firm as a member. That is another privilege. You need to give only 14 days notice instead of 21 days notice for the general meeting. This is also a privilege. So like that, they have many privileges, and that is possible because we have given you a license to operate as a Section 8 company. They can use, instead of the word limited or private limited, they can use more suitable names such as clubs, chambers of commerce, etc. They enjoy the same privileges and obligation as a limited liability company. So the liability is limited. Then they have separate legal status. There is perpetual succession. So they get to enjoy all the benefits of a company. But sometimes what happens is, people are skeptical. They don't want to enter into a contract with a Section 8 company having limited liability. So that is why we say in your name, you need not add the word limited. Instead, you can use chambers, you can use foundation, club. This is giving an impression to the third party that the liabilities are unlimited. This is not fraud, it's one of the privilege. License will be revoked if the conditions are contravened, if you start earning profit, if you start aiming profit, or you start distributing dividend. Minimum number of directors, independent directors does not apply, again a privilege. Alteration of memorandum and articles require you should mention previous approval of ROC, can be asked as a question in the exam. Please highlight it. Now, this was also asked in the RTP. Okay, this was asked in RTP May 22. The company was a Section 8 company. They altered the memorandum and articles, but they sought the approval of ROC after the alteration. Is that okay? No, you need to obtain the approval before. Okay, previous approval of ROC is required. So in this case, previous approval of ROC will be required if you want to alter the memorandum or articles. What if I take the approval later? Then that is in violation of the act. So students, these are the most important concepts of Section 8 company. They may ask you what are the privileges of Section 8 company. So you need to write the privileges, like it need not use the word limited or private limited. It enjoys the same privileges. 14 days notice instead of 21. No need to write, no need to have minimum number of directors, independent directors, etc. Partnership firm can be a member. So these are the privileges of a Section 8 company. Then we have another important concept, small company. Why important? Because there were amendments, but question has not been asked on this concept, so they can ask in your attempt. The amendments were in the rules, not the definition. Many students get confused. They amend the definition. There is no change in the definition. Section 2 clause 85 defines a small company as it is a small sized private company. Now we are of the opinion that why should a private company be subject to all the compliances? Just because you're a company doesn't mean that you should be subject to all the compliances. So there is some relief, there is some benefit to a small company. Okay, so there is less of compliances. If the paid up capital, this is the first requirement, if the paid up capital does not exceed 50 lakhs or such higher amount as may be prescribed. What is prescribed? They have given here. The turnover as per the profit and loss account does not exceed. This is the second requirement. The word is and. It means both the requirements should be satisfied. Only then you will get the benefit. You will be called a small company. So here the paid up capital is not more than 50 lakhs and the turnover is not more than 2 crores or the higher amount as may be prescribed, then you are a small company. Now these limits have been prescribed. The higher limit is prescribed. So what should you consider? As per the company's specification of definition rules 2014, this is important. You have to write this in the exam because it is written in the module also. This is how they have written in the module. So in your answer, you will have to write as per the company's specification of definition rules 2014. For subclause 1 and 2, which are the subclauses? This is subclause 1. This is subclause 2. The paid up capital and turnover shall not exceed 2 crores or 20 crore respectively. So now to be classified as a small company, your paid up capital should not be more than 2 crores. So here we are expanding the scope of the definition. Many companies are now coming under the ambit of small company. They are getting the privileges of a small company. So I think this is a good news for small sized private companies. If your paid up capital is less than 2 crores, your turnover is less than 20 crores, consider the higher limits now. Then you can be classified as a small company. But this section does not apply to, this is also a part of the definition. If a question is asked on this, you have to mention the exceptions also. This section does not apply to a holding or subsidiary company. Now let's say that H Limited is a holding company and it has S Private Limited whose paid up capital and turnover is within the limits, but you cannot claim the benefit, you cannot claim the privileges of a small company because you are a subsidiary company. It does not apply to section 8 company because anyways we have given them privileges. A company or a body corporate governed by any special act, anyways the Companies Act does not apply to them. Their statutes will apply. If there is inconsistency, the statute applies. So therefore this benefit, this privilege is not given to such companies. So students, very quickly we have revised something which you had already covered in your CA foundation exam, but nevertheless there are certain concepts which are important for exam. OPC, section 8, small companies. Then questions are also asked on government companies wherein you have to show the calculation. So these concepts are important. Definition of foreign company. Hence, we discussed everything properly. Next, now we will discuss incorporation of a company. Now let us discuss the provisions relating to incorporation of a company. This is something which you have already studied in CA Foundation, and it's the same procedure. So nothing new, but what I have done is I have now written it in a stepwise format so that it is easy for you to learn this for the exam. And yes, this time you have around 2.5 days for the exam instead of 1.5 day. So you can revise the entire syllabus thoroughly. Incorporation of a company. Now, when I want to incorporate a company, the first thing that MCA will tell me to do is decide on the name. So name can be decided by the company, but we need to get its approval from MCA by filling Spice Plus Part A. Now, Spice Plus is the form which we need to file and upload on the website of MCA for incorporation of the company. It has two parts. Spice Plus Part A. Okay, the Part A is for application of name. It is for name application. And Part B, that is the form which you need to fill for incorporation, providing all the details and documents for incorporation. So through Part A, we will first apply for the name. Once we get the name, you will fill Part B. You can fill Part B even before that, but it is better to have a confirmed name. Otherwise, you'll have to, change the procedure. You have already filled the Part B for incorporation. You have not got the name with which you have incorporated a company. It will be a hassle. So you should always advise your clients to first apply for the name, get the name confirmation, and everything is super fast because it is online. So you get name confirmation in a few days, and after that you should fill Spice Plus Part B. So first, we will fill an application form, apply for the name, and yes, you should be careful that the name should not resemble the name of an existing company. It should not be undesirable. It should not hurt any social, religious sentiment. It should not contain certain words. For certain words like association, board, committee, you need the approval of the central government. These are the things that should keep in mind. The name should be adopted within 60 days of approval. This is for new name. You need to adopt it within 60 days of approval. After this, you should draft your memorandum and articles of association. Once they are drafted, then these documents are to be e-filed. Everything is electronic. The entire process is electronic. E-file and e-stamp along with the incorporation form. So there are three forms involved now: INC 32, INC 33, INC 34. INC 32 is your incorporation form. Everything is available on the website of MCA. You just need to fill the basic form for incorporation, submit the attachments whenever asked. So submit INC 32, 33, 34. So 33 is for memorandum, 34 is for articles. These have to be e-filed and e-stamped. Okay, you can pay the stamp duty while filling the form. It can be done online. You can also physically pay that, but I don't think anybody does that now. Nowadays, they pay the stamp duty while filing the incorporation only. After this, consent of the persons nominated as directors should be submitted electronically. Now, you have named that these are the directors of my company. How will the ROC verify whether those persons have actually agreed to be the director of your company or not? Obtain their consent letter. Now, in my memorandum and articles and incorporation document, I have written that Mr. Mukesh Ambani has agreed to be the director of my company. MCA is surprised. How will Mr. Ambani agree to be a director of such a small company? Give his consent. So I may write name of any person, no, to verify ROC. They are not coming, no, to check these documents physically. So they are relying on whatever you are filing. So they say, give us a consent letter. We want to verify whether this person has actually agreed to become a director or not. So we will write a consent letter that I have agreed to be the director. I'm already a director in these companies. It is within the limits. So that consent letter will be filed with ROC. It will be submitted electronically. Submission of statutory declaration of compliance and other declaration. So I need to obtain a compliance and declaration from the directors who are internally involved, the company secretary, that we have complied with all the requirements of the act. Then you can also obtain it from either a CA, CS, CWA. or CMA, that all the requirements have been complied with. See, ROC is relying on whatever you file. So they want a declaration from these people who are involved in the formation of the company that all the compliances have properly been complied with, all the requirements are complied with. Directors also need to give a declaration that they have not been committed of any fraud, misfeasance. Do you remember that? They need to fill, like, I remember when I had incorporated my company, it's a private limited company. So I am a director. I had to give a declaration that I have not been convicted of any fraud, misfeasance. I have not been guilty of any fraud in relation to the incorporation of the company. There is no offense or pending procedures against me. I had to write all that. If you want, there is a format which MCA provides. There is what you need to write, that is already provided by them. You just need to type it on the letterhead of the company, sign the document, mention your DIN, director identification number, and submit it along with the incorporation. So that you had studied in foundation, same logic, same provisions apply here also. Pay the registration fee, which is very nominal. I remember I had incorporated a company in less than 5,000 rupees. Obtain a certificate of incorporation which is signed by the ROC. Everything is given electronically. Even I received my certificate of incorporation electronically. It was digitally signed by the ROC. Digital signature was affixed, not a physical handwritten signature. So the ROC will sign it. Corporate identification number will be mentioned here. This is like a number given to every company. It's a unique number, like a roll number given to the company. When you enter the corporate identity number SIN of the company in MCA's website, you will get all the details of that company. Same logic applies for director identification number. If you enter that number, you will get all the relevant details relating to the director, the other companies in which he is a director, when he became a director, when he ceased to be a director. You should file a declaration about the address of the company. So declaration, other declaration will include this also. I have mentioned that this is the registered office of my company. ROC's next question is, give me proof. So you will have to file maybe your electricity bill, telephone bill, water bill, or your ownership documents, or maybe a rent paid receipt that this is my registered office and here is the proof. So that declaration is also required to be filed. So these are the 7 steps to incorporate a company. Very easy to remember. Students, as I mentioned earlier, you can get a hard copy as well as a soft copy now of the chart book from my website theorymasterslearning.com. I'm leaving a link of the chart book. Main aim is that you should enjoy learning law. It should be fun. These charts have a perforation, so you just tear the chart and paste it on the study table or the wall where you're studying. If you don't have space, it is a smaller space, then just tear the chart, keep it in front of you. If you don't want to tear it, like many students don't want to do that, so if they want to keep it in the book, you can keep it in front of you while you study the theory from your textbook. So when you see the provisions every day, automatically you will start remembering it. And why is it in color? Because your main textbook as well as the compiler, that is in black and white. So there should be something which your mind can distinguish from the regular notes. So these images, these colors, the format in which we have prepared the chart book, that will remain in your eye like a picture. And in the main exam, you will remember, this was the color, something was written over here. So to distinguish between your normal text and to help you remember, like many students say, ma'am, we don't remember law, we are not able to remember law. So this is one way of remembering law, memorizing the important points. Then you can elaborate all this in the exam. No? Earlier, we used to make these notes. Like I remember when I was a student, I used to make all these notes in my book. But you guys have only 9 months to study, prepare for exam. You don't have time to prepare your own notes. So this will help you. Next, let us discuss section 3A, company to maintain minimum number of members. Now, capital A shows that this is added through an amendment. How many minimum members required in case of private company? 2. In case of public company, 7. This number should be maintained throughout the lifetime of the company. What if in case of a private company or a public company, the number falls below this minimum number? Like say for example, I have a public company, members were going by car, met with an accident, only 5 members survived. Now the number has fallen below the minimum requirement of 7. Law says that you can continue your business for 6 months. Because yes, we agree that it takes time for you to find members, or you may be in shock. You can continue the business with this reduced number for 6 months, but after 6 months, persons who remain the member, who were the members during those 6 months and after that, they will be severally liable for the acts of the company. Number of members has reduced below 7 in case of public company, 2 in case of private company, and the company has carried on business with this reduced number for more than 6 months. So for 6 months, you can continue business with the reduced number. But after that, you need to reinstate the number. Then every person who is a member of the company during those 6 months, the next after those 6 months, so persons who are members during those 6 months of reduced number and after 6 months, and they know, okay, they have knowledge, this is very important, they know that the company is carrying on business with this reduced number, then they shall be severally liable for whole of the debts of the company contracted after those 6 months. They can also be severally sued upon. So in this case, if you are aware that the company is carrying on business with the reduced number, then you will be liable, severally liable for all the debts of the company. Okay. Then we have commencement of business section 10, very important for exam, can be asked as a short note. I personally feel that this can be asked as a short note, so you should know the provisions. Now let's say that my company's authorized capital is 5 lakhs, but I have paid up capital of 2 lakhs. Paid up means the directors or promoters will be a better word. The promoters have promised that we will bring 2 lakh rupees as paid up capital. Now, at the time of incorporation, in the memorandum and in the not memorandum, but in your company formation documents, you must have mentioned the paid up capital. Memorandum will mention only the authorized capital. Paid up capital is mentioned in your incorporation document, that this is the amount of capital that we have contributed. In the memorandum, there will be a table wherein you will subscribe. Okay, you will subscribe means you have agreed to purchase the shares. So let's say that there are two promoters, and they have each agreed to buy 10,000 shares of rupees 10 each. They have decided to contribute 1 lakh rupees. Okay, 1 lakh rupees. Now ROC says, prove it. Prove that you have actually brought in 1 lakh rupees in the business. Give bank statement. Give me some proof. How will I know that you have? It is possible that you have just written I will contribute, but you have not yet brought that cash in the business. It means that you're not carrying on the business. I'm doubtful. So, company incorporated after the commencement of the Companies Amendment Act 2019, and having share capital. So, you are a company incorporated after the Companies Amendment Act 2019 and you have share capital. You will not be allowed to start your business, commence means start business, or exercise borrowing power unless declaration is filed by the director. You have to file a declaration. You are declaring that within 180 days, it's not 6 months. 6 months comes to 182 days. It is 180 days of the incorporation, that every subscriber means person who has subscribed to the memorandum and agreed to purchase the number of shares mentioned against his name. So in the memorandum, in the clauses, we will write the authorized clause, but in that table in the memorandum we will be studying later, that you will write the number of shares that each subscriber has agreed to provide and subscribe. So a declaration will be filed by the director within 180 days with the registrar, that every subscriber to the memorandum has paid the value of shares agreed to be taken by him on the date of making the declaration. You have to submit the bank statement, some proof that you have actually brought in cash in the business. If the registrar feels that you are not carrying on the business, you have not even brought capital, you have not brought what you promised, and you have not filed a verification of registered office, it means you don't have money, you have not contributed money, you are not even providing me proof of your registered office, it means maybe you're not doing business. The no declaration is filed, registrar believes that the company is not carrying on business or operation, then they may initiate action for removal of the name of the company from the register of company. So your name can be removed if you do not file this declaration and you do not submit a proof of your registered office. So if ROC has reasons to believe that maybe, you're not carrying on the business because you're not submitting these documents, then he may take action for removal of the name of the company from register. So it will be as if you are an unregistered company. What if at the time of formation, at the time of incorporation, so let me highlight at the time of, change the ink. If at the time of incorporation, ROC finds that you are trying to provide false or incorrect information, or you're trying to suppress the information, that is hide information, show less than what it actually is, then they will refuse to register your company. What if the ROC finds that you have registered the company by providing false, incorrect statements, by suppression of facts? He finds this after incorporation, then what action can be taken? Both are important for exam. They can be asked separately, or a combined question can be asked as to what action will be taken by the ROC if he finds that wrong information was given at the time of incorporation, and what action can be taken if we find that you had given false information but we find it after incorporation. Now, how are you supposed to read this? If any person furnishes false or incorrect information, furnishes means provides, gives incorrect, false particulars, suppresses any material information, material means important, of which he is aware, in any of the registration documents filed with ROC, then he shall be liable. Okay, then he shall be liable, or you can write this as 3 and you can change this to 4. Then he shall be liable for action under section 447. Section 447 is punishment for fraud. So imprisonment, fine, both. This is punishment for fraud. It's a common section. You need not write the provisions of section 447, but if you are very confident, you can go ahead. Here they only want you to mention the section number. So if any person furnishes false or incorrect statement, you're doing it knowingly, you're providing wrong information. Suppressing means hiding. This is fraud. You are aware of. Aware is an important word, because you cannot blame someone just because he's the director or he's a promoter. Then he shall be liable for action under section 447. But what if by mistake ROC registered the company and later he found that false information was given, facts were suppressed? The company, ROC later finds that the company was incorporated by furnishing false or incorrect information, representation or suppression of material fact, information, or by any fraudulent action. Then the promoters, first directors, and the persons making the declaration shall be liable for action under section 447. So the promoters, first directors, persons making the declaration, like we saw in the earlier case, there are many persons who are required to make declaration, like directors, chartered accountant, that all the compliances have been properly complied with, company secretary. So if they are aware that false information was given, then they shall be liable for action under section 447. Same provision that you studied in CA Foundation. What are the keywords over here? The company has been incorporated by furnishing false or incorrect information. Representation, here it is not innocent, it is fraudulent only. Suppression of material fact, you are suppressing, providing less facts, or you're hiding information, and you are incorporating the company. Now, you may ask me, for example, ma'am, how can you suppress information? What false information can be provided? Let's say that the company registered itself under a registered trademark, but that trademark did not belong to the company, it belonged to someone else. So they are falsely registering the company. They are providing false information that this trademark belongs to us. The officers, the promoters, or any person involved making declaration shall be liable for action under section 447. So students, these were the provisions relating to incorporation. Now let us discuss the provisions relating to memorandum and articles. Yes, I totally agree that this was already covered last year in your CA Foundation syllabus, but there are many new provisions like how to alter the name clause, object clause, then what is entrenchment, section 19. So these are few new provisions that you will be studying in CA Inter. What kind of questions can be asked? Theory, case-based question. They may ask you a provision to write the theory on alteration of name clause, alteration of object clause. All these are very frequently asked questions. So now let us discuss memorandum and articles of association. Let us discuss memorandum and articles of association. Now, memorandum is the basic document on which the company's edifice or the structure is based. So it is a basic document. It is also known as a charter. It defines the scope of powers of the company. Company can perform only those acts which are authorized by the memorandum. Any act which is beyond the scope of memorandum is ultra-vires and hence void. It is not binding on the company even if the company obtains the approval of each and every member, even if the company obtains unanimous approval of every member. If I have a garment manufacturing company, the company is authorized only to manufacture garments. Can the company manufacture tires? No, because it is not within the scope of powers of the company. If you want the company to manufacture tires, then you'll have to specifically authorize that through the memorandum. So memorandum is the charter of the company. It is the basic document on which the company is incorporated. It defines the scope of power. It also restricts the power because the company can perform only those acts which are authorized by the memorandum. Then what are articles of association? Articles are the rules, the regulations. Whenever I explain to the students, I always say what is to be done, that is mentioned in the memorandum, and how it is to be done, what are the rules, what are the regulations, that is mentioned in the articles of association. So memorandum, we'll define that first, we'll discuss that first, and then we will go to articles. So memorandum is the charter of the company. It is the basic document which defines the scope of powers of the company. Let me zoom it for you. So it defines the scope of powers of the company. There are different clauses in the memorandum. Now, what kind of question can be asked on this? They will not, I think, ask you a question where you have to describe all the clauses. But yes, they can ask you a question on any of these clauses, like what is name clause, what is the procedure for alteration, what are object clause, what is the procedure for the alteration of object clause. So what is name clause? The first thing that we need to define, decide is name of the company. Yes, the name should not be undesirable. It should not be, it should not hurt any religious or social sentiment. It should not resemble the name of an existing company. Now, this will be read with Rule 8, 8A and 8B, which says that the company's name should not resemble the name of an existing company. It should not be undesirable. And in case you need to use certain words like board, authority, then you need the prior approval of the central government. So name clause should mention name of the company that with which it is registered. The name of a private company will end with the words private limited. The name of a public company will end with the words public. It will end with the words limited, and OPC will end with the words OPC private limited. You have to write all this in the exam if a question is asked on the name clause. The name should not be undesirable. It should not hurt any social, religious sentiment. It should not resemble the name of an existing company. I cannot have a company in the name of Reliance Fans Limited because it is a company which is using the name of an existing company. It is a registered trademark. The use of certain words like board, authority, union, national, all this requires prior approval of central government. So there are certain words which if you want to use, you will first have to obtain prior approval of the central government. What if I want to alter the name clause? Now, why will a company alter a name clause? We should know that first. See, if the company has changed the objects, they may want the name to reflect the objects better. You can change the name. Suppose there is some merger and or amalgamation, and you want the name to reflect that, you need to change the name. Sometimes the company is known by its abbreviated version. Like, how do you know Life Insurance Corporation of India? Who says the entire name? We always say LIC. Unit Trust of India, we never say the entire name, we say UTI. So sometimes the company is known better by its abbreviated version. In that case, the company may want to change the name. Or it resembles the name of an existing company, so the central government will give us an order and we have to change the name. Name change can be either voluntary or compulsory name change. Let us see both of them. If I am voluntarily changing name of the company, the first step is that I need to pass a special resolution. Board will recognize the need for alteration of the name, so they will pass a board resolution confirming the name alteration. Then they will propose it to the shareholders, who will pass a special resolution for name change. Special resolution is passed, copy will be filed with ROC. You also require approval of the central government if we want to change the name of the company. Name change will not be allowed if the company has defaulted. You should highlight this provision. Name change will not be allowed if the company has defaulted in filing the annual return, financial statements, repayment of matured deposits, debentures with interest. Now the company has defaulted in paying the loan. Company changed the name. We are not going to allow your name change. You cannot just escape from your liability by these tactics. So name change will not be allowed if you have defaulted in filing of the annual return, financial statements, or repayment of deposits along with interest or debentures. This was for voluntary name change. Okay, these provisions are for voluntary name change. Section 16, very important for exam. Section 16, there was an amendment also, so it is important for exam. Okay, I'll just use another different coloring. It is important for exam. This talks about compulsory name change. Maybe the central government has realized that the company's name is identical with the name of an existing company. So they may on their own order name change, or sometimes an existing company will complain to the central government that, see, this newly registered company is using my name, please order it to change the name. In that case, the central government will give you an order and you have to change the name. So this compulsory name change is discussed under section 16. Timeline within which I need to enforce that change, within which I need to make that change, is also given in section 16. The company will change the name in 3 months. You should know 3 months. This, you should remember the timeline. Company should change the name within 3 months from the order. They will change by just passing an ordinary resolution and previous approval of central government. Central government's approval is required because you're changing the name. So the central government will give you an order. Within 3 months of receiving that order, you need to change the name by passing an ordinary resolution and previous approval of central government. If the name in the opinion of central government is identical or it resembles the name either of an existing company or a registered trademark. Now this is a registered trademark of Tupperware. Okay, so Tupperware, you will find they write the word R. It means it's a registered trademark. I started manufacturing the goods in the name of Tupperware. I just wrote it in a different manner like this. Okay, now this is resembling the trademark which is already registered. So the registered owner of trademark shall within 3 years go to the central government and they will request the central government to pass an order for name change. So the central government shall within pass an order, and within 3 months, by passing an ordinary resolution and the previous approval of central government, the company which is registered next will have to change the name because it is already resembling the name of a registered trademark. How will I come to know whether my trademark is being used by someone or not? That effort has to be taken by the company which has registered the trademark. So Tupperware will every year they do this. Every year they will, either their team, the legal team in their company, or maybe an IP advocate, that is intellectual property advocate, will go through various registrations, magazines, or there is a list provided of the trademarks which were registered up till date. So they will have to go through and find out whether their trademark is used by any other company or not. That effort will have to be taken by the registered owner of trademark. New certificate of incorporation will be issued under the new name. So these are the provisions for voluntary as well as compulsory name change. That 3 months timeline is important. Provisions for compulsory name change can be asked as a separate question. Just because the company has changed name doesn't mean that it has become a new company. The identity remains the same. Only name has changed. Okay. Next, Then we have the registered office clause. In the memorandum, do we need to mention the exact address? No, we only need to mention the state where the registered office is situated. Exact address can be communicated to ROC separately. Now, what is the use of registered office? Registered office is used for communication, serving of notice, necessary documents, letters. Now, if I want to communicate with a company, I will have to send that communication to the registered office. ROC wants to communicate with the company wants to hold the meeting, maintain the books of accounts. All that is done at the registered office. That is a main place of communication. I should, within 30 days of registration in corporation, send a notice of the exact address with verification of documents to the ROC. So in the memorandum, at the time of registration, I will only mention name of the state. I will communicate the exact address to the ROC later. Okay, so exact address will be communicated to the ROC later. But the ROC will also want proof. Otherwise, what will happen? You will say that this is my registered office. But what about proof? Now, I am saying that this entire room is my registered office. ROC will definitely ask me for a proof. Show me the ownership documents, or if it is on rent, show me the rent paid receipt, show me the electricity bill, water bill. You give me some proof that you are using this place as your registered office. So that will be sent within 30 days, and the verification will also be given to the ROC. If I want to alter the registered office clause, if the change is like say from this building to the next building, then we need not trouble the members. Board of directors can take that decision. We will go to the members only when the change is from, let's say, one city to the other city, one ROC to the other ROC, one state to the other state. If the change is within one state to the other state, state has changed, it means you need to alter the memorandum. Otherwise, memorandum will not be altered if you are changing from, let's say, one city to the other city, or one ROC to the other ROC. If you are changing from one ROC to the other ROC, now this is possible only in two states. One is the state of Maharashtra and other is the state of Tamil Nadu. These are the two states which have two ROCs. See, generally one state, one ROC. But in these two states, that is Maharashtra and Tamil Nadu, we have two ROCs because there is a lot of business registered. There are many businesses which operate in these two states. So one ROC will be burdened. In Maharashtra, we have ROCs in Mumbai and Pune. In Tamil Nadu, we have one in Chennai, other in Coimbatore. So if you're shifting from one ROC to the other ROC, you also need the approval of regional director. Now, let's say, for example, I am shifting from Mumbai ROC to Pune ROC. Okay, or from Pune to Mumbai. There is a regional director. Now in India, there are 4 regions: North, South, East and West. Each of these regions has a regional director and all the ROCs are under these regional directors. Okay. So all the ROCs of the North will report to the regional director. Now I am changing from Mumbai to Pune. I will have to inform the regional director also that please note I am shifting from one ROC to the other ROC. I am shifting from Mumbai to Pune ROC. So we will have to inform this to the regional director. He will also give his confirmation. His confirmation along with the special resolution will be filed with ROC. So we are shifting from one ROC to the other ROC, very frequently asked in the exam. So the section numbers, that is section 12, is also important. You will pass a special resolution, obtain approval from the regional director. So let me highlight this in point format. The first is you will pass a special resolution, you will obtain approval from the regional director. Then you will file this with the ROC. The special resolution as well as the approval of the regional director will be given to the ROC. He will register and certify the change. All right. So the ROC where you have gone will issue a new fresh certificate of incorporation with his details. If you're changing from one state to the other, yes, now you need to alter the memorandum because memorandum is mentioning the state. It has changed now. There may be various reasons for changing from one state to the other. Better administration purpose, better tax purpose, better laws. My labor is located there, so now I can make goods in a cheaper manner. There is less of transportation. There are so many reasons for shifting from one state to the other state. You will first pass a special resolution. This is step number 1. Obtain approval from the central government. But yes, the central government has delegated this authority to the regional director. Okay, so this has been delegated to the regional director. Obtain approval from the shareholders, debenture holders, any other creditor or parties whose interest is likely to be affected. Now, there may be a portion of shareholders, a section of creditors who are not open to this change. Okay, they may object. So either obtain their approval or settle their claim. The special resolution has been passed. It means there are many who are in favor of the change. But if there are few who are objecting to it, either you obtain their approval or you settle their claim. You can't force anyone to continue with the company. Obtain from the ROC a fresh certificate of incorporation. So the state where you have shifted, you will obtain a fresh certificate of incorporation indicating the alteration. So these are the few main points for alteration. Most of the times questions are asked from shifting of one ROC to the other ROC or shifting from one state to the other. Then we have the object clause. Object clause will state the purpose, the objects for which the company is formed. So it will mention the purpose for which the company is formed. Now, my company is a garment manufacturing company. I can manufacture only garments. So someone who is investing in this company will be aware of the risks of investing in the company. Now, we know that garments enjoy a certain amount of risk. If there is risk, there is return. So what is the risk? That, you know, someone may come supplying a cheaper source of the same fabric, or there may not be any demand because like in lockdown, people were not going out of their house. So what will they do by buying new clothes? So that time there was very less demand of garments. So there was a lot of risk involved. What if I want to export the goods, but there is some error in the manufacturing and the export order is rejected, or there is some export exchange fluctuation? So there are many risks involved. What is the object that will help us to determine the risk that we are undertaking by investing in the company? So it contains the objects, the purpose for which the company is incorporated. It enables the shareholders, creditors, and others dealing with the company to know the scope of work and also to know whether they can enter into contract with the company or not. Now, if I am a garment manufacturing company, but I come to you for manufacturing 100 tires, I take your order for manufacturing 100 tires. Is my memorandum authorized to it? Does it allow me to manufacture tires? No. This is an ultra vires act. Company is not liable. Company will say that I am not liable. Third party, you should have checked whether the company is authorized to manufacture tires or not. This is the doctrine of constructive notice. Yes, do you agree? So the third party should check the objects of the company, whether the company is authorized to manufacture those goods or not. Any act beyond the object clause is ultra vires. It is hence void. Such act cannot be ratified even with the unanimous consent of each and every member. There is a very important case law, Ashbury Railway Carriage and Iron Company versus Ritchie. If a question is asked on ultra vires transaction, you have to compulsorily mention name of the case law. You need not explain the case in detail, but yes, the name is important. You have to mention the name if a question is asked on the ultra vires act. So whenever a question is asked on ultra vires, you will explain the meaning of ultra vires. When is it ultra vires? You will also mention that it cannot be ratified even with the consent of each and every member. Mention the name of the case law. What if I want to alter the object clause? Now the company is a garment manufacturing company. They have also started trading business, or maybe they are utilizing the money which they had raised from public issue for some other purpose, like I want to manufacture accessories or shoes. Now, whenever people invest in the company, let's say the public, okay, this is the public, they have invested 10 crores in the company, thinking that the company is going to use this money for manufacturing of garments. But I now want to use out of this 10 crore, 4 crore rupees for manufacturing shoes or other accessories. Now, the company has utilized 6 crores for manufacturing of garments, but they are diverting the unspent amount in some in manufacturing some other type of goods for other objects. You have to inform the shareholders, people who have given money thinking that you are going to use it for manufacturing garments. You have to inform them that no, out of 10 crores which you had given, I have used only 6 crores. I could not allocate 4 crores. It is lying with me. Now I'm thinking of manufacturing shoes which will complement the garments. There is a huge market for shoes. So you have to through a notice, inform the members, ask them to pass a resolution, obtain their approval. If they don't give their approval, then you have to settle their claim. In case of the company which has raised money through the prospectus, now this is applicable only when you have raised money through the prospectus. It is applicable only when public is involved. They have given you money thinking that you're going to use it for a specific purpose. Money is lying unutilized. Now you want to use it not for the purpose for which you raised, but for some other purpose. Then what is the first step? The first thing that you need to do is pass a special resolution. Ask the members, seek their permission. Can I use this money for some other purpose? If you are passing a special resolution, your next sentence should be a copy of which will be filed with ROC. Then you will publish this in the newspaper. Why publish it in the newspaper? See, whenever we went to pass a special resolution, we gave a notice to the members. In that notice, we mentioned everything: the amount raised, the amount utilized, the amount lying unutilized, how we are planning to use that money, why we are using it for some other purpose. Everything will be mentioned. There are people who don't receive the notice because maybe they have changed the address and not updated that with the company. So we need to give a notice in the newspaper for people who complain that we have not received the notice. So publish it in the newspaper, also place it on the website of the company so that anyone who says that we have not received the notice can go to the website and see. Yes, now you may say, ma'am, no, not everyone goes to the website every day, no? But see, these are ways of notifying to the public. Once we have published on the website, we assume that you must have read it. There are people who do not give their approval. So give them an exit opportunity. They may not agree that no, we don't want our money to be used for manufacturing of shoes. There is a lot of risk. We want our money back. Give them an opportunity to exit. ROC will then certify and register the alteration. We will give him the memorandum which is altered, in which we have altered the objects, and he will certify the same. These three alterations are very important for exam. Separate question will be asked. They will not ask you how to alter name clause, object clause, state in one question. Different questions will be asked. Next, we have the liability clause. Now, liability will mention whether the company is a company limited by shares, or it is limited by guarantee, or whether it is an unlimited company. In case of company limited by shares, the liability is limited to the unpaid amount on shares. If the shares are of, let's say, face value 10, you have paid up 6 rupees. Now the company can demand from you only rupees 4. Okay, this is the only liability. You will not contribute anything beyond 4 rupees. Then in case of company limited by guarantee, yes, we have already discussed this in types of companies. The liability is the amount that they undertake to contribute at the time of winding up. So it may be a guarantee company having share capital. It may be a guarantee company not having share capital. If it has share capital, there will be two liabilities. One is the amount of the share, and other will be the amount of guarantee. The amount of share can be recovered anytime during the lifetime of the company, but in case of guarantee company, you can recover only at the time of winding up. In case the company does not have share capital, you have only one liability, that is the amount of guarantee, and this can be claimed only at the time of winding up. Okay. Then we have the capital clause. The memorandum will state the amount of share capital with which the company is registered. It means that they will mention only the authorized capital. Details of the amount which is paid up or any other details will not be mentioned. So only details like I have authorized capital of rupees 5 lakhs divided into 50,000 shares of 10 each. That's it. That's the only information given in the capital clause in the memorandum. Any breakup, further details can be mentioned in the articles. Number of shares that each subscriber intends to undertake. So that is also the association clause. Every subscriber will indicate the number of shares against his name. In the memorandum, there is a small table. In that table, you will mention the name and the address and other details of the shareholder and the number of shares that he has undertaken, and that the face value as well as the amount. So there are two members, they have each decided to purchase 10,000 shares. So total we have 1 lakh. So the paid up capital is currently 2 lakh rupees. So this table will be mentioned in the memorandum. At least they should subscribe for 1 share. And it should be at least 1 share. I'll highlight that. Name of the nominee in case of OPC. We had studied this. If you have an OPC memorandum, will mention the name of the nominee. Any alteration in the name will not be deemed to be alteration of the memorandum. It means that even if you change the name of the nominee, you need not follow the procedure for alteration of the memorandum. It's not considered as alteration of memorandum. So that was memorandum, students. Now let us discuss articles of association. If you are tired, you want a break, you can always do that, because that is the beauty of online lectures. Yes, my speed is a little fast because all this was already covered in CA Foundation and we are just revising. So you need a quick run through. Students, our chart book, I think, will be the best way that you can revise. And always prepare an achievable timetable. Like, I had uploaded a video very recently, and students have appreciated the technique that instead of making timetable for the entire week or the entire month or study period, it is always best to make short and achievable timetable. Like, I always tell my students to make a timetable for 1 week, or if you don't want to do that, at least for 3 days. So prepare a timetable for Monday to Wednesday. Then Wednesday you should always keep half a day free for the pending work. Then on Thursday, Friday, Saturday, Sunday, you should prepare a timetable for these 4 days. Keep Sunday half day for pending work. So such kind of achievable timetable will also increase your confidence. You will end up studying more. And when you tick, yeah, completed this, I have completed, it gives you a sense of satisfaction and pride that you could manage to achieve. Then you start improving and your concentration level increases. So I think these are small tips which you should keep in mind while designing your timetable. Okay, so next let us continue with articles of association. Articles, they are internal documents. So these words are very important for it, that it is an internal document. It contains rules and regulations. Now, I have authorized the company to borrow money. Okay, so the memorandum has authorized the company to borrow money. Company is authorized to borrow money. But what are the restrictions on borrowing? Is it that company can borrow any amount that they want? No, there are restrictions. So what is the restriction that will be mentioned in the articles? Company can borrow only up to rupees 5 crores, beyond which you need to pass a special resolution, seek approval of the members. So whatever are the restrictions that will be mentioned in the articles. They contain regulations for the management of the company, how the company should be managed, what are the rules, regulations, restrictions that will be mentioned in the articles. I want to conduct meetings. So what is the procedure for meeting? What is the procedure for voting? How to transfer shares, transmission? Everything is given in the articles. Alteration of articles, very important for exam. It can be asked as a 3-mark question. Entrenchment can also be asked as a 2-mark question. Now, if I want to alter the articles, yes, articles may be altered, but when? When I want to convert a private company to the public company, I will remove the restrictions. That requires alteration of articles. I want to convert a public company to a private company, I will have to put those restrictions. Yes. So alteration of articles is required. Whenever you want to alter articles, it is effected only by a special resolution. Okay, so I need to pass a special resolution. Alteration may include conversion of private company to a public company to a private company. We need approval of central government when the public company is converted to a private company. Okay, so public company is converted to private company, you require approval of central government. Alteration of articles will be made, and a copy of articles as well as the approval of central government, if we require, will be submitted to the ROC within 15 days. Alteration once registered, it will be as if it always existed in the articles. It will have a retrospective effect. So it will be as if you were always authorized to perform that act. Now let's say that the director of the company borrowed beyond 5 crores. Now they could not borrow beyond 5 crores except with the approval of the shareholders. Now they borrowed 7 crore rupees without the approval of the shareholders. Since the company was authorized to borrow by the memorandum, this is not ultra vires the memorandum, it is only ultra vires the articles. It can be ratified, or it can we can alter the articles and confirm this act. So it depends on the company. They can either say no, we are not bound by 7 crores, or they can say that we are bound only for 5 crores. director, you will be bound for 2 crores. Or the company is an extremely kind company. They say, okay, we will alter the articles, raise the limit to 7 crores and we will bind the company by this amount. So it all depends on how the company is trying to alter the articles, because it's an internal document. You can always alter it and accept all the acts which are altered via the articles. It has a retrospective effect. So by alteration of articles, we are accepting this 7 crores as if he always had the power to borrow 7 crores. All right. What is entrenchment? The meaning of entrenchment is mentioned over here only, students. Making something more protective. I'll give you an example, and it's an excellent example to understand this point. Entrenchment means to make something more protective. Okay. Now, A is the director of a company. It's for the time being a family owned company. But later he thinks that what if we have to dilute our shares and the majority shares are held by non-family members. In the articles, it was written that he will be appointed as a director for life. But he is also aware that in case the company is diluted and the shares are in the hands of a non-family members, majority shares are held by non-family members, even though it is mentioned in the articles that he is to be appointed as a director for life, just by passing a special resolution, obtaining approval of 75% of the members in the meeting, those non-family members can always remove him as a director. So what does he do? He puts an entrenchment in the articles. No, not 75. I require 95% of the members to vote in favor of me being removed as a director. So only when 95% of the members will give their approval for removing me as a director, only then you can remove me, otherwise not. So don't you think that he is making the articles more protective? Instead of special resolution requiring only 75%, through the articles we are requiring 95% of the people to give their approval, only then X can be removed as a director. This is nothing but entrenchment. You are making the articles more protective. You're protecting your interest. Nobody can remove you as a director unless you obtain the approval of 95% of the members present in the meeting. Specified provisions of the articles may be altered only if the more restrictive conditions or procedures are complied with. So in this case, you can alter the articles, you can remove him as a director only when you obtain approval of 95% of the members. Provisions may be made either on the formation of the company or by amendment in the articles. Okay, so you can entrench the articles either at the formation or anytime after that. If you are a private company, for entrenchment, you require the approval of all the members. And in case of public company, you can entrench the articles later just by means of a special resolution. So entrenchment 2 to 3 marks, if it is asked as a 3 mark or maybe a 4 mark question, then you will have to explain the example also. And the example which I just discussed with you is an authentic example, is from the module. You can easily explain that in the exam. The last part over here, section 19, subsidiary company shall not hold shares in the holding company. Now H Limited is the holding company owning 70% in S Limited. S is the subsidiary. Can we allow subsidiary to purchase, let's say, 20% in the holding company, 10%, 5%, 2%? How can you control your controller? Yes or no? How can you control your controller? So should we consider that you own 20%, I own 70%, so net we own only 50%, whether we are a subsidiary or not, that is now in doubt? No, we cannot allow the controlling company to control the controller. So in this case, law says that subsidiary company cannot buy shares in the holding company. Any allotment made will be void. No company shall hold shares in its holding company either by itself or through nominee or through any other investment company. No holding company shall allot shares or transfer shares to the subsidiary. Such allotment or transfer shall be void. But there are certain exceptions. Under these exceptional cases, subsidiary may hold the shares of holding company. What is the first exception? This is important for exam question is asked, and in case a case-based question is asked, then they generally ask on this third point. Okay. Now, where the subsidiary company holds shares in the holding company, you will highlight in the capacity of a legal representative of deceased member of the holding company. Let me give you an example to explain this point. Mr. X was the shareholder of H Limited. Now he died. We know in case of death, the shares are transmitted to the legal representative. Coincidentally, legal representative is S Limited. Since a company is a separate person in the eyes of law, this is valid. So X died and his shares were transmitted to S Limited. S Limited is the legal representative. Now, is S Limited, the subsidiary, holding shares as the owner? No, they are holding shares only in the capacity of a legal representative. So we don't see any harm in the subsidiary holding the shares of holding company as a legal representative. It will exercise its right only in the capacity of a legal representative, not the owner. What if H Limited has a member X and he has transferred his shares to S Limited, who are holding them only as a trustee? We are holding those shares only as a trustee for benefit of some other person. Now here, where the subsidiary is acting only as a trustee, it's not the owner. You're only a caretaker of those shares. This is allowed. What if the subsidiary was already holding 2% shares of holding before it became a subsidiary? Then you can continue holding the shares even after you became a subsidiary. You need not surrender your shares just because you have become a subsidiary. You will also get to enjoy all the rights of member except voting rights. Okay, so this is the third provision is important for case-based question. So students, with this we complete the entire discussion on, wow, it's looking pretty, you know, so many markings. We have completed a quick revision of memorandum and articles of association. Next, let us discuss prospectus and allotment of securities. So what is a prospectus? Now, let's say that the company wants to raise a lot of money. So they will have to go to the public because banks and the existing shareholders will not be able to fund that. So they went to the general public. They said, we need money. I'm assuming the company is into construction and they want to construct a dam. So they said, we want to construct a dam. So we need money for working capital. We need money to buy machinery, etc. Will you please pay money? Now, the general public is quite interested, but they want to know how you're planning to use this money. Are the shares going to be listed? If yes, then where? Who are the underwriters? What is the underwriting commission that you're going to give them? What is the profitability of the company till now? What is the rate of dividend that you're giving? There are so many questions which the investors have in their mind. You cannot expect them to find all this information on their own through Google. So what the company does, they prepare a document. In that, they give all the relevant information regarding that issue to the prospective investors. Prospective investors read that document, fill the application form attached to it, submit it to the company will allot shares. So don't you think it is a very simple way to obtain subscription from the public? Give them a document, give them the information that they require, and then it will help them to subscribe for the shares of your company. So that document which is given to the investors to help them decide whether or not to purchase the shares of the company is known as a prospectus. Even when you go for admission in a college, or maybe you want to go abroad for MBA, so you will want to know about the college, about the courses offered, whether the college is A grade college or not, what the facilities, the subjects offer. The prospectus is a document which will help you to decide whether or not you should take admission in that college. Even ICAI gives you a document, a prospectus, when you register in foundation. Yes. So prospectus is a document which helps the investors to decide whether or not they should invest, whether or not they should purchase the shares of the company. How is it described? It is defined under section 2, clause 70 of the Act. Prospectus means a document described or issued as a prospectus. So any document which is described or issued as a prospectus is a prospectus. So if on the document I have written that this is prospectus of the company, so it is prospectus. It includes a red herring prospectus as defined under section 32, or a shelf prospectus as referred to in section 31, or any other notice, circular, advertisement, any other document inviting subscription from the public. So the types of prospectus is included in the definition itself. Red herring prospectus, shelf prospectus, any document, notice, advertisement will be considered as a prospectus. It is a deemed prospectus. Yes, students, they are referring to deemed prospectus. Yes, it is deemed prospectus. You are giving this document for subscription or purchase of any securities of the body corporate. The word subscription, it means an agreement to buy shares. It's an agreement to buy shares or securities. I think that is a better word. It is a wider term, to buy securities. Okay. So it's an agreement to buy securities. I don't want the entire money now, but at least you promise that whenever I call, you will pay this money. That is nothing but subscription. So now the shareholders have subscribed. It means they have promised that we will pay the face value whenever you want. You want it now, we are ready to give. If you want to make calls, we are ready to give whenever you demand. Or purchase of any securities of the body corporate. All right. So definition is important for exam. You will have to memorize it, because sometimes they ask you a general question, so you will have to write the definition, or they say define a prospectus. In that case, you will have to write. Then, if you are a public company, what are the different ways in which you can raise money through offer of securities? So we have public offer through prospectus. Please note, students, that prospectus is required only in case of public offer of securities. If you are going to the public, you need to inform them about your company. You need to inform them about the issue. But if you're going for private placement, bonus shares, right shares, private placement is to a selected group of people who already know about the company. Bonus and right shares, they are to existing members who are already aware of the company. So no need to inform them through the prospectus. Therefore, prospectus is required only in case of public offer of securities. What about public offer? It can be either IPO, that is initial public offer, when the shares or securities are offered for the first time by the company. Up till now, I had never gone to the public. This is the first time that I'm going to the public. This is the first time that my shares are being offered. FPO, once the shares are offered and then you go for the second or the third time, it is known as a future or further public offer. Further public offer, not future, further public offer. Then you have offer for sale of securities, which is section 28. Now in this case, certain persons like directors or maybe any private equity investor, yes, director, private equity investor, or a major investor, they want to exit from the company. But if in the market you come to know that the director is exiting, the investors are exiting, it creates a negative sentiment in the market. So they offer the shares to the company, and company offers the shares to the public on their behalf. Of course, the company is giving them some service, so they will charge for it. But when they sorry, what am I saying? When the company agrees to dispose the shares on behalf of these persons, like I can write directors, private equity investors. Private equity investors are those who give you money and you give them shares in return. They now want to exit. So company will offer shares on their behalf to the public. So along with, let's say, IPO, the company is offering many shares. Along with that, they will offer these few shares also. Public will subscribe. PE investors will get money. Let's say they get 200 crores, whereas they had subscribed for the shares of the company only for 50 crore rupees. They will make a good profit of 150 crores and exit. So this IPO, etc., is actually an exit strategy for these private equity investors. So if they are offering shares to the public, it will not create a negative sentiment. Although we inform them that out of so many shares we are offering, these shares belong to certain persons. but then the public is not very aware of it, or they don't read it properly maybe, but it doesn't create a very negative sentiment in the market. So offer for sale, that is also considered as public offer. You have to issue prospectus. Public is involved, prospectus is required. A private company can offer shares through either private placement, rights issue, or bonus issue. So private company doesn't have the option of going for public offer of security. So they go for private placement, bonus shares, or rights shares. What are the contents of prospectus? It is discussed under section 26. So what are the basic requirements of the prospectus? Students, you should know that prospectus is the only document on the basis of which investors decide whether or not to purchase the shares of the company. So law says that whatever is mentioned in the prospectus must be true and accurate. There is a list that we need these disclosures in the prospectus. So law is very vigilant. They're very clear that because the public is involved, you have to inform them about these things. So what are the contents of the prospectus? Prospectus must be properly dated. If the date is not mentioned, then the date of publication will be considered as the date of prospectus. We have to submit this prospectus to the ROC. Now, physically it is not required. You just have to file it with the ROC. And as soon as the company gives it to the ROC and ROC gives his approval, then within the next 90 days, you must issue that prospectus to the public. If I go after 100, 200 days, then we will assume that this is a prospectus, a copy of which has not been filed with ROC. Allotments made will be considered void. So there is a time limit, because the prospectus, it contains information which will not be valid for long. But for 3 months, we will give you time. Now that ROC has approved it, go and issue it to the public within 90 days. So the company has to issue it to the public within 90 days of filing with ROC. Physically, no document is required to be submitted. Everything is online. Filing is with ROC. It should be signed by either the directors, proposed directors, or attorney of director, someone who is authorized by the director to sign on his behalf. So signature is important because it shows authentication. Otherwise, it will be an incomplete instrument. On the cover page, of the prospectus, we will write that we have obtained the consent of the expert if the expert is appointed. Now, let's say I want to construct a dam, and for that I am raising 1,000 crores. Okay, I am raising 1,000 crores. Now, people will not trust me, but if I engage an expert, the expert is giving an opinion whether the project is viable or not, whether we should go ahead or not. Now, expert says that yes, the project is very good, dam should be constructed, these are the villages that will be benefited, this is the environmental impact, this is how the company is going to earn, they are going to make profit. So if an expert gives his opinion, the public will trust the company more. So that is why we obtain consent of an expert. Yes, he will act as an expert, he will give advice, his report will also be, the extracts will be published in the prospectus. Copy of underwriting agreement. Sorry, I think I missed that part. I went ahead. On the cover page, we will write that a copy of this document has been filed with ROC, and there are certain attachments to be made. These are those attachments or endorsement. So they will write that yes, we have attached and endorsed this to the ROC. So that will be written on the cover page that this is the prospectus, a copy has been filed with ROC, and there are other documents and attachments which we have also filed. Endorsements or attachments will include consent of the expert. I discussed that. Written consent of auditor, banker, attorney to act in that capacity. Copy of underwriting agreement, if any. Details of contract with managerial personnel, with KMP, with your managing director, fixing their remuneration, etc. The prospectus will be approved by lead managers, underwriters, and stock exchange. Lead managers, they lead the company, they guide the company in the IPO or FPO, that is public offer. So we go to a lead manager, they will guide us as to the documents, the listing agreement, they will create a positive sentiment in the market, encourage people to purchase shares of the company, help us with advertisement, road shows, etc. Stock exchange, we have to apply to the stock exchange, and this application should be made before you go to the public, because if you apply after you obtain the application money, and what if you don't get the approval, you'll have to return the application money. So it is best that you seek the approval of the stock exchange before you go for public offer, and the prospectus must mention the stock exchange where your shares are proposed to be listed, and also whether you have obtained the consent or not. Underwriters, yes, underwriters, they agree to purchase the shares in case of undersubscription. So if the public is not buying, these people will buy it. So underwriters to the issue, they agree to purchase the shares of the company in case of undersubscription. It's like an insurance contract given. It's an insurance contract for the company. So they are obviously undertaking risk. For this risk, they get something known as underwriting commission. So what is the rate of underwriting commission? How much are you planning to give? Are you going to utilize the proceeds of the issue? All those details should be mentioned in the prospectus. So there are disclosures we have to disclose that information. Then we have deemed prospectus, section 25. This is considered to be as if it is a prospectus issued by the company. Now, what happened was the company, it allotted shares to the issue house, maybe an underwriter or an investment banker. They allotted shares to the issue house, and the issue house then offered the shares to the public. Both company and the issue house avoided the issue of prospectus. When we went to the company, they said that we have not offered these shares to the public. Since public is not involved, we have given all the shares to the issue house. Since public is not involved, we don't think that we should issue prospectus. Yes, that's right. They have not gone to the public. So we went to the issue house that you are going to the public, please issue prospectus. So they are saying that why should we issue prospectus? These are not our shares. We are only offering them on behalf of the company. And also they would treat this, they would show as if this is an investment of the issue house in the company. They said no, it is just like an investment and we are selling these investments, so why should we issue a prospectus? Both avoided the issue of prospectus. Then the Companies Act became very smart. They said, all right, in that case, whatever document you use, you call it notice, circular, document, any piece of paper that you use to offer shares to the public will be considered as if it is a prospectus issued by the company, and all the provisions of prospectus shall apply. So in this case, unless proved otherwise, the document will be treated as a prospectus if it is shown that. Now, these are the important provisions. That is why we are discussing it. So you have to show that the shares were or securities were offered to the public within 6 months after they were allotted or agreed to be allotted to the issuing house. So do you understood what is the deemed prospectus? Any document, notice, circular, advertisement that you use for offering shares to the public will be considered as if it is a prospectus issued by the company. Even the provisions relating to misleading prospectus will apply here. So the issue house argued that this is just an investment and we are offering it to the public. Then we said, then why are you doing it on immediate basis? If it is an investment, you will not offer it before 6 months. No, you will want to hold it. So here, if we are able to show that the securities were offered to public within 6 months of them being allotted to the issuing house, then it means that you never had the intention of holding it as an investment. Your only intention was a well-planned business activity to offer shares to the public. So they became very smart. They said, okay, we'll go after 6 months. So we added one more condition by writing or. So if any of these two conditions are satisfied, it will be a deemed prospectus. The second condition was that the whole consideration was not received by the company. What did the issue house do? They offered shares to the public, as in when they would get money, they would pass it on to the company. The issue house argued that this is our investment. So we showed it to them. If this is your investment, why haven't you paid the entire amount to the company at once? Why are you paying it in installment as and when you receive it from the public? It means this is not your investment. This is a well-planned business activity. If this was your investment, you would have given the entire money to the company, but you're not doing so. As and when the public is giving you money, you are then passing it on to the company. This is a deemed prospectus. It is like a public issue. All the provisions of prospectus will apply. Then we have a shelf prospectus. Today, the word shelf means that it comes with a shelf life. This prospectus is valid for a period of 1 year from the first offer of security. So shelf means it has a shelf life. Now, in case of companies that is offering shares to the public multiple times in a year, like I need to offer securities 2 or 3 times in a year. So every time if you ask me to issue a prospectus, it is a costly affair, it is time consuming, and the information will remain same in every prospectus that I issue in that short period of time. So instead of issuing prospectus every time, I will offer shares shares only once. Sorry, I will issue a prospectus only once, and it will be valid for a period of 1 year from the first offer of security. After 1 year, if I want to issue more, then I will go for a fresh prospectus. Prospectus in respect of which securities or class of securities are issued for subscription in one or more issues. We go for multiple issues over a period of time without the issue of further prospectus, then it is known as a shelf prospectus. It has validity of 1 year. It has a shelf life from the date of the first offer of security. So it has a life of not 1 year, calendar year or financial year, but the year starts from the first offer of securities. Now, if I am going to issue prospectus only at the time of first offer of securities, then what about second, third, and fourth? There may be changes, no? Of course, we will have changes during the second, third, or fourth offer of securities. Of course, there will be changes. So, law says in order to highlight the changes taking place between the first, second, third, and fourth offer of security, if there are changes in this period, then you need to file an information memorandum. Okay, you need to file an information memorandum. That information memorandum will highlight the changes which took place between the first, second, third, fourth, fifth, whatever the number of offers that you have given in that year. It will highlight the changes during that period. What are the changes? Like, I purchased new asset, I have given some asset as security. What are the major financial changes that have taken place? Just inform the investor. So information containing all the material facts relating to new charges created, financial position that has changed, all that will be highlighted through the information memorandum. Information memorandum and the shelf prospectus will be considered as the final prospectus of the company. Okay, it will be considered as the final prospectus of the company. Then we have the red herring prospectus. Red means danger. Okay, red mean, oh, why did I cancel it? Red means danger. Why? You're trying to highlight that this is an incomplete prospectus. Some information is not mentioned over here. Like, I'm not sure about the issue price. I don't know at what price they will buy the shares of the company. So the issue price, issue size, that is quantum, is not mentioned. Now what happens is that the company is not very sure as to the price that it should offer the shares. Like, you are my chartered accountant. I come to you and I say that I'm offering shares for the first time. I don't know what price I should offer. You tell me. It is very difficult for you to pinpoint that offer at 400, 300. I don't know. So what the company does, they go to a lead manager. The lead manager informs the public about the issue, creates a positive market sentiment, asks them at what price they are ready to buy. Then he will decide a range. Like, the public is saying they want to buy from around 400 rupees to 425 rupees. The lowest is known as the floor price and the highest is known as the cap price. In this case, the public is ready to buy in this range. So in the in the in the red herring prospectus, we will mention only the range. Then the applications will be received in this range only. The price at which I receive maximum application will be the final price, issue price of the company. Now I know the issue price, I know the issue size, I can complete the prospectus. Again, a final prospectus will be filed with ROC. So I will have to file red herring prospectus, incomplete, as well as the final. When I file the final prospectus, I will highlight the changes made. Prospectus which does not include complete particulars of the quantum or the price of securities, that is known as a red herring prospectus. So it's incomplete. It has to be filed at least 3 days prior to the opening of the subscription list. When I am ready with the information, I will prepare the final prospectus and file it with the ROC, highlighting the changes made. Abridged prospectus. Now, if you ever see the prospectus of the company, it is around 100 to 150 pages. Do you really think the public has time to read all that? No. So what we do is we just eliminate the information that is not required for them and choose the information which an investor actually requires to take the decision. Like, who are the directors, what is the profitability of the company, what is the future projection of the company, and how much dividend have you paid. So the information which shareholders actually require, only that information is given in the abridged prospectus. So it is a shortcut, it is an abridged version, a shorter version of the prospectus of the company. It contains all that information which is relevant, but it is open to the company whether you want to issue a full prospectus or an abridged prospectus. Even if they give an abridged prospectus, they will keep the full prospectus with themselves, because there are some certain sunky shareholders who say no, we want to see the full prospectus of the company. So to them we can't give just the abridged prospectus, we will have to provide the complete prospectus of the company. So abridged means it's a memorandum containing such salient features as may be prescribed by SEBI. They will say that these are the requirements of the abridged prospectus, at least disclose this much. It should provide adequate disclosure. Adequate word is very dangerous because it is so subjective. It must be attached to every application form, and a copy must be furnished whenever required. This is very important for exam circumstances where prospectus or abridged prospectus is not required to be issued. So these are certain circumstances wherein you need not issue a prospectus or even an abridged prospectus. When we offer shares to underwriters, they already know about the company. Why do we need to offer a prospectus? Securities which are not offered to the public, when public is not involved, like in private placement, rights issue, bonus issue, you need not inform them, they already know about the company. Securities offered to existing members only, this includes bonus and rights issue. Securities which are similar in all respects which are offered earlier, in this case we offer a shelf prospectus. They are similar to the securities which we offered in the past. Securities issued by private company, this will include private placement. So when public is not involved, when you're going to the existing shareholders or you are going to a limited group of people, prospectus is not required. So very, very important for exam. You will have to elaborate these points, but in the chart book, we have only highlighted the points so that you can remember the headings and then elaborate in your own words. So this was types of prospectus. Then let us discuss misstatement in prospectus. Can be asked mostly as a theory question, but yes, case-based questions have also been asked in the past. Misstatement in the prospectus. Yes. Now, prospectus is a document on the basis of which investors decide whether or not they should purchase the shares of the company. If it contains wrong, incorrect information, misleading information, then yes, you will be subject to penalties. So misstatement means, how will I understand whether it is a misstatement or not? It is misleading in the form and context in which it is included. Now, for misleading statement, you can have misstatements include misleading statements. It includes inclusion or omission of some material fact. Now, misleading statement means instead of giving information about the individual declining dividend, I give information about average dividend. People will think that the company is a profitable one. They will never come to know that the average is calculated from a declining trend. Inclusion, I have included statements which are false. In my prospectus, I wrote that Mr. Mukesh Ambani has agreed to become the director of the company, whereas he had only agreed to help me in incorporation of the company. People read this information, they purchased shares at 500 rupees. Later, they found that this information was false. The price fell to 200 rupees. Every shareholder suffered 300 rupees loss per share. So this damage can be claimed from the company and the persons who have given that false statement. Omission, I have omitted some fact. I have given information about the dividends of 5 years, but I did not mention the fact that the dividend is given out of capital profit instead of revenue profit. This information was not given in the prospectus. Prospectus is misleading because of the omission. You are omitting some very important fact. You're giving an impression that the company is a profitable one, but you have failed to mention that the dividend is out of capital profits instead of revenue profits. This will make the prospectus misleading. It is misleading in the form it omits a material matter. If a question is asked, students, you have to write this definition in the exam. It is very, very important for you to write this in the exam. Okay, so you have to start your answer by explaining what is a misleading prospectus, be it a theory question or a case-based question. If there is misstatement, you can file either criminal liability arises or civil liability. Over here, we have given remedies against the company. So you can take action either against the company or against the directors, promoters, experts. They are personally liable. So you can cancel the contract as soon as you come to know about the misstatement. You can also claim damages for deceit or fraud under section 19. Section 19 says that contract where the consent is obtained by coercion, undue influence, fraud, misrepresentation, it is voidable. So yes, we also have 19A for undue influence, but here it is saying that it is voidable when the fraud is involved. So you can cancel the contract, you can claim damages. How to claim damages? I have shown it to you. We bought shares at 500, price reduced to 200, 300 rupees per share is the loss. You can also take action against the directors, either criminal or civil liability. See, in case of criminal liability, there is imprisonment. How will I know whether it is civil or criminal? The civil liability is generally against the person who is filing the case. Only he has suffered damage. But in criminal liability, there are many people who have suffered damage. In civil liability, you are filing case only against the concerned person, whereas criminal is generally against the state. So if many people are involved, and also students, most important, in case of criminal, mens rea, that is more important. Mens rea means you should have guilty mind, intention to cheat. If it is proved, then there is criminal liability, otherwise it is civil liability. So in criminal liability, intention, if it is to cheat, it is criminal. Every person who has authorized the issue of prospectus, can be a director, proposed director, can be even a chartered accountant who has authorized the issue, they will be punishable under section 447, which is punishment for fraud. But if the directors, they prove that we thought the information was like immaterial, or maybe that inclusion or omission was required, we had reasons to believe that inclusion or omissions were required, then in that case they will not be proceeded against. Civil liability against the company, director, proposed director, expert, one who has authorized the issue of prospectus, they will be held liable for damages. But if they prove that we thought the matter at the time of consent was required to be included or omitted, we had reasons to believe, and we also believed in that statement depending upon the facts, or maybe when we came to know about it, we withdrew our consent, but in spite of that, the prospectus was issued, or the prospectus was issued without our knowledge, without even informing us, allowing us to check the information, then yes, they can escape the liability. So students, this is important because it is asked as a question in the exam. It is very frequently asked. When is the director or expert not liable? Expert is liable only for the incorrect statements made in his report, not if the incorrect statement is made in the entire prospectus. This part is important for exam. When is he not liable? Then last part, we have private placement, section 42. Yes, section 42, private placement. Instead of going to the public, we have decided to go to a selected group of people whom we are very confident will invest in the securities of our company. So we go to a selected group of people. Who identifies them? Board of directors. So in the board meeting, they will approve of the list. This is the list whom will offer securities. This is the number of securities offered. So offer is made or invitation is made to subscribe to a selected group of people other than public office. And how do you inform them? We give them a letter, offer letter of private placement. That offer letter, okay, private placement offer letter, this is an offer. It's not invitation to offer, it's an offer. We will send the application form, they will fill the application form, we will allot the shares, they will be the yes, they will get the shares. So it is just an invitation to subscribe for the securities. So we are giving them an offer letter. This offer cannot be given to more than 200 people in a year. What if I give this to more than 250 people? See, it is possible that I may give it to a selected group of people. Not all of them may subscribe, but through private placement, not more than 200 in a year. Okay, I cannot give this offer to more than 200 in a year. I cannot allot shares or securities to more than 200 people in a year through private placement. If I do that, if I allot to more than 200 people, then it will be considered as a public offer and all the provisions of public offer will apply. But in calculating this 200, we will not include the qualified institutional buyers, that is QIBs. QIBs will include your institutions like mutual fund, insurance companies, which invest a lot of money in these securities at once. It will not include the employees who are offered the securities under the employee stock option. So up till now, we have discussed that the private placement offer letter will be given to selected group of people. Board of directors will decide to whom the offer is to be given. It cannot be given to more than 200 people in a financial year. If we allot shares to more than 200 people in a year, it will be considered as a public offer and all the provisions of public offer will apply. The company shall issue private placement offer letter and application to identified persons who will fill and submit the form along with the money, either by check, demand draft, other banking channels, not by cash. I cannot invest my cash in private placement. I will have to give either check or net banking or any other demand draft, any other banking channel, not cash. The board will also have to maintain a list of the bank account from which the investors have invested money. So Mr. A gave from SBI Bank, Mr. B from HDFC Bank. You will have to maintain a list so that we come to know whether the money is received from banking channel only, not cash. Money will be received, but it will not be utilized until all the allotments are made. It will be kept in a separate bank account. So money received will be kept in a separate bank account with a scheduled bank. It will not be utilized until the allotments are made, and even after allotment it will be used only for the purpose for which the issue or the money was raised. You will also file a return of allotment with ROC within 15 days of allotment, specifying the securities that you had offered, the consideration that you have received. If you have received other than cash, then what is the consideration, when was the allotment made, the persons to whom the allotments were made, all the details regarding the allotment will be mentioned. If you don't file the return of allotment, see, there is penalty also. There is penalty. Okay, the private placement offer letter will not carry a right of renunciation. To renounce means to give up in favor of some other person. Okay, to give up in favor of some other person. So you are giving up the securities in favor of other person. This is possible in case of rights issue, but not private placement. In rights issue, if you don't want to buy the shares, you can ask your friend, you can renounce it in his favor. But in private placement, if the offer is given to you, only you can accept it. If you do not comply with the provision, it will be treated as a public offer, and all the provisions of public offer will apply. Now, as soon as we have applied for the shares, okay, within 60 days the company will allot securities under private placement. If they fail to do so, they will return the amount within the next 15 days. If the company does not repay the amount within the next 15 days, they will have to pay it along with interest at the rate of 12% per annum, and this interest will be calculated from the 61st day. So even though we are giving them 15 days to arrange for payment and make money, but the interest will be calculated on the 61st day. So within 60 days of receipt, we will have to allot the securities. If you fail, then you have to refund the money within the next 15 days from expiry of 60 days. If you fail, you will have to pay it along with interest, which will be calculated from the 61st day. So students, these were the provisions relating to private placement. Very, very important for exam. It is my gut feeling that this time they may ask you a question on private placement. Theory, case-based question, MCQ, case-based MCQ, anything can be asked on this concept. So very, very important for exam. Next, let us discuss allotment of securities. A very small part over here, because as I informed that not many questions are asked from allotment chapter. There are only specific sections on which question can be asked, and Those are minimum subscription, section 39, or maybe underwriting commission. So I have covered both these concepts over here. Now, what's the meaning of allotment? Now, allotment means it gives an impression that there are a lot of shares which are now given to the shareholders. Before allotment, shares, they form part of the capital. It is only on allotment that shares come into existence. Now, let's say that the company has authorized capital of rupees 5 lakhs. And from that 5 lakhs, they want to give the shares. So they will tell people, you buy the shares, you give us money, and we will give you shares. So the general public, they pays money, they pay money, and the company gives them shares. They allot shares to people. Like, I have given you 10 shares, give me money. You want 100 shares, okay, take 100 shares and you give me money. So when we give shares to this person, it is known as allotment. So to allot means to give share to people who have applied for those shares. Allotment is acceptance of offer. So all the essential elements of a valid acceptance will apply to allotment of shares, allotment of securities, I should say. So prospectus is invitation to offer, application is offer, allotment is acceptance. It is only on acceptance that a contract comes into existence. So on allotment, a contract comes into existence. You will have to pay the amount that you have subscribed, that is face value of the security. So earlier there are no shares, it is just capital. It's only on allotment that shares come into existence. Now, acceptance by the company of offer to take shares made by the applicant is known as allotment. What are the statutory provisions? If you see the general provisions, they are same as acceptance. So acceptance must be communicated in the same manner. Allotment must also be communicated through the letter of allotment. Then it must be within the time period or reasonable time. Then acceptance must be absolute and unconditional. So allotment should also be of the application that you have received, but that is not the case in case of when oversubscription is involved. What if the company invited applications and they received oversubscription? Then you will not get the number of shares that you applied for. In that case, it is better that the company writes in the application form that allotment will be made on proportionate basis in case of oversubscription. Okay, so we had studied that allotment should be absolute and unconditional. You must allot shares depending on the application that you have received, but in case of oversubscription, we cannot allot shares in the same number as we have received application. So you may have applied for 100 shares, but because of oversubscription, we can give you only proportionate. So yes, in that case, the company can escape from that particular provision if they write in the application form that we will allot shares on proportionate basis in case of oversubscription. Then it must be as per the conditions. If the offer is conditional, acceptance will also be with those conditions. So these are general provisions not asked in the exam. What is asked are statutory provisions. Prospectus must be filed in case of public offer. So if you're offering shares to the public, you need to first give a prospectus. Any allotment made without a prospectus, if it's a public offer, will be void. So allotment made without prospectus will be void, but it is required only in case of public offer. Subscription list must be kept open for minimum 3 working days. What is subscription list? See, you have invited subscription from the people. Come apply for the shares of my company. Give them at least 3 days to decide. They will have to go through the prospectus. They will have to arrange for money, fill the application form. Give them at least 3 days, maximum 21 working days if the issue is not underwritten, 10 working days if the issue is underwritten. Actually, the maximum limit is not given in the Companies Act. It is prescribed by the stock exchange or the ministry. So here 21 working days if the issue is not underwritten, because you need more time in that case. But if the issue is underwritten, then the underwriters will bring their contacts, so less number of days are required, and in that time it is possible for you to accept applications or lot shares, because your requirement will be met due to the contacts of the underwriter. So 10 working days if the issue is underwritten. No allotment shall be made unless the minimum subscription as given under section 39 has been subscribed and the sum payable on application has been received by the company within 30 days of issue of prospectus. If you have not received, then you will have to return it within 15 days from the closure of the issue. You can also add over here along with interest, okay, along with interest at the rate of 15% per annum. So what is minimum subscription? That is the minimum amount that you're expecting to raise from the public issue. See, when you want to, when you are calling money for some specific purpose, like I went to the public and I said, I want to construct a dam, I need 1,000 crores for that. If I don't get 1,000 crores, I will not be able to start the project. I received subscriptions for only 600 crores. Now, out of 1,000 crores, I received only for 600 crores. Law says since the minimum subscription is not subscribed, people have not agreed to buy the shares, please return whatever money that you have received. But if I make allotments, that allotment will be void. What is the use of minimum subscription? Minimum subscription is required when you want to buy assets, like I want to construct a dam. I need assets, machinery, I need to engage labor, I need working capital requirement. I will also have to uh, maybe take loan for buying these assets. I may have taken loan, I can repay it from this amount. So minimum subscription is of use to the company. If we have not received subscription, now what is the meaning of subscription? Is it that people should pay the entire face value? No, not compulsory. They should subscribe means they should only agree for the time being that whenever demanded, you will give them the face value whenever demanded. Now you give only what the company requires along with application. So subscription means agreement to purchase the shares. We will give the face value whenever you demand. Now how much do you want? You want 5 rupees along with application? Here, take 5 rupees. But that money should be received within 30 days from prospectus. Company has not received, return it along with interest at the rate of 15% per annum within 15 days from the closure of the issue. Application money should be at least 5% of the nominal value or any other percentage prescribed by SEBI. अभी तक तो नहीं है. So 5% should be received along with application. If you don't receive 5% and you make the allotment, then the allotment will be an irregular allotment. So when is allotment irregular? The cases are given here only. We have allotted shares without issuing a prospectus in case of public offer. The application money is not 5% of the nominal value, or maybe the contents of the prospectus are not as per the requirement of the act. So in that case, the allotment will be irregular. Application money, whatever you have received, shall not be utilized until allotment is made. And even after allotment, you will use it only for the purpose that you have raised the money. You cannot use for any other purpose. So application money will be kept in a separate bank account. It will not be utilized except for allotment of securities. And if suppose you did not get listing in the recognized stock exchange, then you will have to return the application money. So you can use it only for those purposes. Company making allotment shall file a return of allotment in PAS3. This is the form number. Return doesn't mean you have to give it back. Return means it's a form that you need to fill in PAS3, mentioning all the details of allotment, like how many shares, securities have you allotted, shares, debentures, preference shares, what is the consideration that you have received, have you received cash or anything other than cash, anything other than cash, what have you received, assets, intellectual property, value addition, what have you received, when was the allotment complete. So every detail relating to allotment will be mentioned in the return of allotment. Section 39, subsection 4, important for exam. Section number is important. If the company defaults, they will have to pay 1,000 rupees for each day of default, or 1 lakh, whichever is less. Yes, we need to memorize this penalty. It is important for exam. It is asked in the exam. Return of allotment can also be asked as a short note. Then we have underwriting commission. Now, underwriter is like insurance. They agree to purchase the shares in case of under subscription. So if they're giving an assurance to the company that don't worry, if the issue is underwritten, if people are not buying, we will buy. They are taking a lot of risk. For this, for this risk, they charge something known as underwriting commission. Contract between the company and certain parties known as underwriter, in which the latter agrees to secure subscriptions. Okay. Conditions to be satisfied for underwriting commission. Okay, so in which the latter agrees to secure people who are interested in buying the securities of the company. The first requirement is that you must have authorization by the articles. Articles must authorize you to appoint underwriters and to pay commission. How will we pay? From where will we arrange money? You can pay it either out of proceeds of the issue. Let's say I raised 1,000 crores for construction of a dam. Underwriters helped me a lot. I can give commission from this amount that I have raised, but inform the members in the prospectus that I'm going to use the proceeds for issue of for giving underwriting commission. This is the percentage. Or you can also use profit of the company. Now you can write down, you can add over here that commission can be given in either percentage terms or lump sum amount. It can be given in cash or kind. Cash means that you can pay by check, or maybe you can, give money. Kind means, let's say I don't have money, but I'm a builder, I can give a flat. Even if you're giving it in kind, the amount, the value of that flat should be within the prescribed limits. So I can pay it out of the proceeds of the issue or profit of the company, or I can use both also. So I should write 3 over here so that you don't miss out. Commission can be paid either in cash, kind, as a percentage, or a lump sum amount. Details should be mentioned in the prospectus. What is the maximum limit? Maximum, it includes, in case of shares, you can give 5% of the issue price or the amount or rate authorized by the articles, whichever is less. This is super, super important for case-based questions. Super important. Now, law allows you to give 5% of the issue price as commission, but articles, they allow only 4%. So what is the percentage that we can give as commission? Only 4%. Whichever is less. If the articles, they allow you 8%, can you give 8%? No. Then we will consider 5% of the issue price, that is the lesser amount. In case of debentures, you can give 2.5% of the issue price or the amount or rate. Amount means you can give it in lump sum, rate means you can give as percentage, or the rate authorized by the articles, whichever is less. Articles allow only 1%, so you can give only 1%. Articles allow 4%. No, you can give only 2.5% because that is what is allowed by the Act. So please remember this. You have to memorize this. Wordings should be as given in the table. This is how you will write in the exam. So students, this was something related to allotment. Let us discuss share capital, shares and share capital. Now there are different kinds of shares. We have equity share capital and preference share capital. Equity, yes, they are shares which are not preference shares. Preference shares are those which carry preferential right. So they have right to receive dividend before it is given to the equity shareholders. They have a right to receive the repayment of capital before it is paid to the equity at the time of winding up. So preference shares are those which carry preferential rights with respect to dividend and repayment of capital at the time of winding up. Equity shares, they may be with voting rights or with differential rights as to voting or otherwise. Now, with voting rights means generally one share, one vote. Differential rights means the company will decide, let's say 5 shares will give you 1 vote. 10 shares will give you 1 vote. So the company will decide the number of shares. Now, I am a shareholder who's not interested in voting. But because I'm sacrificing my voting, I will get more dividend. I'm interested in dividend. So I will want to purchase the DVRs. Now, from the company point of view, I don't want the controlling interest to be in the hands of the public. I want them to be in the hands of a few people. So the existing shareholders don't want to give up their decision making power. The promoters want to keep the voting power with themselves, so they issue DVRs, give less voting rights to the other members. Now, what are the conditions to be satisfied for issuing DVR? Very, very important for exam. Can be asked as a short note, 4 to 5 marks. Can be asked as 4 to 5 marks. So in this chapter, students, you will feel that the notes are very simple, very easy to understand. There is not much of explanation. There is more of learning only, because you need to know what are the conditions to be satisfied to issue bonus shares, rights issue, for the issue, that is rights issue, or DVRs, ESOP. So these conditions are properly given to you in the chart book. All right. So what are the conditions to be satisfied for DVRs? The first condition is that there must be authorization in the Articles of Association. Articles should authorize the issue of DVRs. Then you need to pass just an ordinary resolution in the general meeting. Just because the articles are authorizing doesn't mean that you can issue. You need the approval of the existing members. Voting power to these DVRs should be less than 74% of the total voting power of the company. So you cannot issue DVRs which have more than 74% of the voting power. The company should not have defaulted. And yes, I forgot to mention that the 74% is aggregate of all the DVRs that you have issued. So voting power of all the DVRs should be less than 74% of the voting power of the company. No default in filing of the financial statements, annual returns for the past 3 years. The company should not have defaulted in paying the dividend, deposits, redemption proceeds, repayment of loan interest. Now you are saying that you don't have money to pay all this and you want to issue DVRs. Very good. First, complete your existing obligations. Only then we will allow you to issue dividend, differential voting rights. In DVRs, you are giving them more dividend. From where will you get that dividend? You're not even fulfilling your existing liability. So first you repay the term loan, the dividend, redemption proceeds, and then you think about issuing DVRs. The company should not be subject to penalties imposed in the last 3 years. It can be by SEBI or by RBI, FEMA. Okay, so you should not be subject to penalties. The disclosure should be made in the board's report that we are issuing DVRs, and we should mention the details also in the register of members. Okay, so what is the procedure? First, you need authorization in the articles, pass an ordinary resolution in the general meeting. The voting power of all the DVRs issued maybe at various occasions should be less than 74% of the total voting power. The company should have not defaulted in their existing liability. No penalty imposed in the last 3 years. You should disclose this in the board's report, and also disclosure required in the register of members. So if you remember these bullet points, you can easily elaborate them in the exam. See, this is what we require, students. You should be able to remember the bullet points, the head points, the keywords. Sentence can easily be framed in the exam. If I talk about preference shares, there are different types of preference shares. We have cumulative preference shares, non-cumulative. Cumulative means dividend accrues, and non-cumulative, in case the dividend is not paid in a particular year, it will lapse. Participating preference shares also get a right to participate in the profit which is left after giving the equity dividend. They may also get a right to participate in the surplus left after at the time of winding up. So first we will pay the preference shareholders, equity shareholders, and whatever surplus is left, that will be divided among the preference and equity holders. These are participating shares. Non-participating, they only get dividend. Convertible preference shares and non-convertible. Convertible will be converted into equity on the expiry of the period. Non-convertible will be redeemed. By default, the shares are assumed to be cumulative, non-participating, and non-convertible. Most important for exam, irredeemable preference shares. Redeemable and irredeemable preference shares. Redeemable preference shares are those which will be redeemed, and irredeemable are those which are not redeemed during the lifetime. They will be redeemed at an event which may not happen, like winding up. They are not redeemable during the lifetime. They will be redeemed at the time of winding up. Our Companies Act under section 55 does not allow a company to issue irredeemable preference shares. You have to redeem them. No company limited by shares can issue preference shares which are irredeemable or which are redeemable after 20 years from the date of issue. So maximum time for which you can issue preference shares is 20 years. But what about infrastructure companies, engaged in infrastructure projects? Sometimes it takes 20 years to just complete the project, or maybe 15 years to complete the project. After that, you will start earning money, have surplus, and you will find the capacity to repay the preference shares, to redeem them. So in case of companies engaged in infrastructure, preference shares may be issued beyond 20 years but not exceeding 30 years. So even there we have kept a cap of maximum 30 years, provided that 10% should be redeemed from the 21st year. So every year at least 10%. So in the next 10 years you will redeem the entire preference share. Redemption. If I want to redeem, I need to arrange for money. From where will I arrange money? Either profits available for dividend, means free reserves, or you can issue fresh uh, issue of securities. Whatever money you get, that can be used. For premium, sometimes you have to redeem at premium. So where will you arrange that premium from? The premium can be provided either out of profits or securities premium account. This is a capital reserve having very specific purpose. We will discuss under section 52. One of the purposes, one of the uses is providing for premium to be paid along with redemption. So yes, you can redeem them not after 20 years, but in case of infrastructure project beyond 20 years but not beyond 30 years, you may redeem them out of profits available for dividend or fresh issue. For premium, you can give profits or securities premium. In case of redemption out of profit, you are using profit which actually was kept for the creditors, so they are scared. See, redemption means repayment of capital. Creditors are scared. So an amount equal to the nominal amount, that is the face value, okay, the face value of shares, which will be transferred to CRR, and this CRR will be available only for my creditors. This can be also capitalized. You can use it for issuing fully paid up bonus shares, but it is basically to provide greater assurance to the creditors that don't worry, even though we are using your money, the profits which are available for dividend, and they were free reserve, they were for your repayment, but we are creating CRR from that profit, so don't worry, later on your capital will be reinstated. You need not worry, company will have enough money to pay you. This can be asked as a short note, students. 4 to 5 mark question can be asked, and the content which I have given in the chart book is sufficient. Section 52 I had mentioned, so let us discuss that first. What are the uses of securities premium account? It's a capital reserve. It has fixed uses. Is very important for short note. There was a time when institute would ask a frequent question on this part. So securities premium can be used to issue fully paid bonus shares. Yes, to issue fully paid bonus shares, to write off preliminary expenses of the company, to write off public issue expenses like underwriting commission, advertisement expenses, discount allowed on issue of shares, debentures, to provide for premium payable on redemption of preference shares or debentures, and to buy back the shares. So this is a very specific use of that reserve. There's nothing to explain in this. You need to learn this. You have to remember all the pointers. Okay. Continuing the redemption of preference shares. In case of unredeemed preferences, now it is not possible for the company to arrange for money always. What if there is a COVID like situation, there was not enough business, all my cash reserves have depleted, I don't have money. So law says that if you are not able to redeem the preference shares, then you can give them an option to subscribe for more preferences instead of the earlier ones, and earlier ones will automatically be deemed to be redeemed. So it's like an exchange offer. Give me your old preference shares, take new, I will redeem after 2 months, after 2 years I will give you dividend for those 2 years, so give us more time. With the consent of 3/4 of the value of preference shares and approval of tribunal. Okay, so we need approval of the holders holding 3/4 of the value of preference shares and the approval of tribunal. We can issue further redeemable preference shares of the amount of unredeemed plus the dividend. See, I could not redeem preference shares. I don't have money to pay dividend or to redeem them. So I'm telling them, you instead of these shares, you take fresh further preference shares. Unredeemed preference shares shall be presumed to be redeemed. We will assume that the earlier ones are automatically redeemed. We have given you a new one instead. We will redeem them after 2 years, promise, pakka. But if people who don't consent, then the tribunal will order for redemption. If I don't consent, no, I want my money. You have promised you will redeem. I want my money. So then for them, we'll have to redeem. Okay, so this is important for exam because it is added through an amendment, and till now no question has ever been asked on this. Next we have further issue of shares. It means they are talking about rights issue. Yes, instead of going to the public, why don't you go to the existing shareholders, let them subscribe to the shares of your company? Yes, so over here you need not even issue prospectus. They already know about the company. If they are not interested in buying, they can renounce it in favor of any other person. That person may or may not be the member. So here you are saving a lot on issuing the prospectus. Cost is saved, time is saved. When the shares are offered to existing shareholders, why to existing shareholders? Because they have a preemptive right, priority. That instead of going to the outsiders, we will first ask our members itself whether they want to subscribe for more shares of the company. They will get it at a better price than the market. Why we need it? For expansion, or we need more funds. When the existing funds are over, the company may want to issue more securities. So students, this what, why, how, when, that will help you to remember the provisions properly. Please remember this in the manner that I have given you in this table form, and you can easily write this in the exam or even elaborate in your own words. How will we do it? We will give it to our existing shareholders in proportion to the paid up capital by sending letter of offer. So give it to your existing shareholders, give them a letter of offer. They can accept it, or they can renounce it. They have the power to renounce, maybe to a member or a non-member. In that letter we will specify the number of shares offered, the time for acceptance, how much time you have for acceptance. So minimum we will give 15 days or less if prescribed, and maximum you can give them 30 days to decide whether or not they want to purchase the shares of the company. So you will inform them that this is the total number of shares that we are offered to you. We are offering this, and generally it is given like I will give you 1 shares for every 2 shares held, 2 shares for every 5 shares held. So they generally give you an offer as to the shares which they are offering in proportion to your paid up capital. If you decline the offer, then the board of directors will be free to dispose of the share in a manner they seem is most beneficial to the company. The offer can be made by notice. Okay, so I'm highlighting notice. We can also give an offer to employees under the employee stock option, or to any person if authorized by the by a special resolution. Can give it for cash or consideration other than cash. We can give it to outsiders also. So there are 3 ways in which we can issue more money. If we can issue shares, that is by notice to the existing shareholders, or you can give it to the employees under the employee stock option scheme, or to any person if authorized by the special resolution. Then we have bonus shares. Bonus means it is given free of cost. It is a capitalization of profit. See, many a times it happens that the company doesn't have money to give dividend. So instead they say you take shares. No, we don't have money to give you dividend. So why don't you accept the shares of the company? Anyways, you're getting these shares for free. You can sell it in the market and you can make good profit. So if the members decide, then it's fine. Instead of dividend, they will accept bonus shares. But if they say, no, we want dividend only, then you cannot compel them to accept shares instead. What? So shares issued without any consideration to existing shareholders. You're not getting anything from them. It is given to existing shareholders. They are known as bonus shares. It is nothing but capitalization of profit or reserve. I don't have any other better use of this profit. And the members, if they don't want dividend because the company doesn't have money, so instead we are giving them shares. Sources, very, very important for exam. You can use your free reserves, securities premium earned in cash only. Securities premium can sometimes be earned other than cash. That is when you receive assets and you give less number of shares. So if you have earned more, given less, whatever is the difference, that is your capital profit, it is transferred to securities premium, that is other than cash. But here you can use the premium earned in cash only, and you can also use CRR. So you have 3 sources. One is free reserves, or a securities premium collected in cash only, or capital redemption reserve. First thing is I need authorization in the articles. Articles must authorize the issue of bonus shares. Just an ordinary resolution is required after the board's resolution. The bonus should be implemented within 2 months. Okay, within 2 months from the approval in the general meeting. So once the approval is given, within 2 months, you have to implement the bonus shares. The company should ensure that the bonus shares are fully paid. Even the existing shares will be made fully paid, and then we will issue bonus shares which are also fully paid. You cannot issue them in lieu of, that is instead of dividend. So if the members want dividend, you cannot tell them, "Arey, shares rakh lo na." The company will be allowed to issue bonus only if there is no default in the payment of interest, deposits, debentures, statutory dues of employees like provident fund, gratuity, bonus, and bonus once issued cannot be cancelled. So first you pay your existing liabilities, only then we will allow you to issue bonus shares. So students, this is something which you are already aware of. You just need to write it properly. Okay, so that work is done by the Chartbook, because I know that students rarely they find time doing this. So it's better that you have something ready made. Next, let us discuss buyback. Super duper important for exam. Very, very important for exam. You won't believe it, in 2 pages we will complete shares and share capital. That's the best part of Chartbook. Everything is covered in less page, and we have A3 size of paper. So it's a beautiful book. Do order it. The link is in the description box. Buyback. Buyback means buying back your own shares. Why? Because there are many reasons actually. The company has a lot of reserves. They don't have any better use of those reserves. So the company has decided to buy back from the existing shareholders. If they invest that money in bank or any other medium, the cost of capital is so high that it is better to buy back your own shares and reduce it. Secondly, I want to increase the earnings per share, the dividend per share of my existing members, which is possible through buyback. So the amount of dividend will now be distributed among less number of members. So definitely earnings per share will improve, dividend will improve, and the company also can utilize their reserves or cash which is available. TCS, yes, they had recently announced a buyback. What is it? It is purchasing of own shares by the company. Sources are extremely important for exam. They can use free reserves, securities premium, proceeds of any shares or other specified securities. Now, if you are buying back equity, you can issue preference shares. If you're buying back preference shares, you can issue equity and use that proceed for buyback. So purchasing your own shares using the free reserve, securities premium, here there is no difference between cash and other than cash. Proceeds of any shares or other specified securities. What is the procedure? First, you require authorization in the articles. Then a special resolution will be passed. So authority in the articles, a special resolution to be passed. Board resolution is sufficient if the buyback is 10% or less of the equity capital and reserves. So board resolution is fine if the buyback is less than 10% of the total equity capital and reserves. Buyback must be completed within 12 months from the date of passing the resolution. So what is the validity period? The buyback must be completed within 12 months from passing the resolution. So this is the time limit for completion of buyback. Gap between two buybacks should be of only 365 days. Minimum 365 days gap should be given. Otherwise, what will happen? Companies will start buying back like every 6 months. No, gap must be at least 365 days. Buyback should not exceed 25% of the total paid up total paid up capital and free reserves. This is the total limit, and it shall not exceed 25% of the paid up equity capital. So buyback of equity in a financial year. So if I talk about total buyback should not exceed 25% of the total paid up capital plus reserves, and buyback of equity in a financial year should not exceed 25% of the equity capital in that year. The maximum debt equity ratio should be 2:1 after buyback. So when you calculate equity over here, okay, debt to equity, sorry, this is equity. When you calculate equity, it should be after you have bought back the shares. So debt, if it is, equity if it is 1, debt cannot be more than 2. In case of buyback, out of free reserves or securities premium, an amount equal to the nominal value shall be transferred to CRR. So this is created specially for creditors. CRR has many uses, like you can use it for issuing fully paid up bonus shares. So if you're using free reserves, which is actually for the creditors, so if you're using their money, they are scared. So in order to pacify them, we create CRR. Buyback will be on proportionate basis. It means that company wants to buy back 100 shares, but they have received an application for 150 shares. People have offered more shares than they intend to buy. So we will go and ask Mr. A, how many shares have you offered? He said 5. So out of 5, how much will we buy back? He says, okay, Mr. B says I have offered 10. So how much can we buy back? It's a simple cross multiplication, and we will buy back on proportionate basis. You can also buy it from the open market, that is stock exchange, or ESOP, that is, or sweat equity. After you have bought back the shares, they will be physically extinguished if they are physical shares, and that must be done within 7 days of the completion of buyback. No issue of the same kind of securities within 6 months of buyback unless you are issuing them due to some requirement or bonus shares, or there was a requirement by the bank. Register will be maintained. Return of buyback will be filed with registrar and SEBI. No buyback if you have defaulted in deposits, repayment of debentures, redemption of debentures, redemption of preference shares, term loan along with interest. So it is very straightforward actually. If you refer from here, these are the requirements, you have to memorize them. What about issue of shares at discount? Can we issue shares at discount? No. Why no? Earlier, the Companies Act 1956 allowed you to issue shares at discount. Why is it not allowed under the 2013 Act? That is because if I have shares of face value 10, and there are many people who have bought at this value, but now I'm issuing shares at face value 8. Sorry. I am issuing face value 10 shares at discount. I am issuing them at 8 rupees. So there are people who have bought these shares at the face value 10. Now you are giving to certain people not face value 10, but face value is 10 only. You are giving them at 8 rupees. You are giving them 2 rupees discount. So why this differentiation? भेदभाव क्यों? Why do some people buy at 10 rupees whereas others are getting the option to buy at 8 rupees? We want everyone to be equal. That is why you can no longer issue shares at discount unless they are sweat equity. Yes, unless they are sweat equity shares. But what if the company has not paid its creditors and they're giving them an offer that, see creditors, we don't have money to pay you. Why don't you accept the shares of my company? I'll give it to you at discount. Go and sell in the market at the full price. You keep the profit with you. So if the creditors have agreed to convert their debt into shares in pursuance of any statutory resolution plan, debt restructuring scheme, then in that case issue at discount is allowed. So we can issue sweat equity and do creditors at discount. If we allot securities at a discount other than these two reasons, then you will be imposed penalty. The amount raised through the issue of shares at discount or rupees 5 lakh, whichever is less. So if I have raised, let's say 2 lakhs by issue of shares at discount, then I will compare it with 5 lakhs, whichever amount is less, that is the amount that we will have to pay. The company shall be liable to refund the amount received along with interest at the rate of 12% per annum. So yes, penalty to bharni hai, you will have to pay the penalty, plus you will also have to refund the amount. So if this question is asked in the exam, there is not much content which you cannot accept this, but I think it is sufficient for even a 4-mark question. You will write the section number and 3 points of explanation with the penalty. Then we have sweat equity. Sweat equity is generally issued to directors and employees at a discount or for consideration other than cash. Why do we issue them? Because they provide us with technical know-how, intellectual property, or value addition. Let's say, for example, my employee has invented a medicine and now he wants to get it patented. So I say that I will buy your patent, I will manufacture it. So employee gives the patent to the company. Company says we will not give you money, instead you accept the shares. He's fine with it. So for that IP, that is intellectual property, he is getting shares. You have helped me to set 6 chemical plants in my company. So instead of rewarding you with money, I will give you shares. And sometimes employees feel that that is a better option because cash will be spent, but shares always appreciate in value. Once the company starts manufacturing, it will definitely appreciate in value. So you are issuing it to directors. They are also putting in lot of hard work. Or you can give it to employees at a discount, like for 10 rupees face value, you will give them at 8 rupees. Face value is 10, but you will give them at 8 rupees. 2 rupees is discount. For value additions that they have brought in the company. So these are various reasons. Now, what are the requirements? First, it should be for the class of shares which are already issued. You cannot create a new class of shares just because you want to give sweat equity. Special resolution will be passed, the validity of which will be 12 months. In that, we will write the number of shares that we are offering, the current market price, the consideration received. If it is without consideration, then what are you receiving? Class or directors or employees to whom this offer is made. We will follow SEBI guidelines if the shares are listed. Sweat equity should be less than 15% of the existing paid up capital or shares of face value 5 crores, whichever is higher. Let's say 15% of the paid up capital comes to 60 lakhs. Compare it with rupees 5 crores, whichever is higher. It means you can issue sweat equity up to rupees 5 crores. But I want to issue only for 2 lakhs. That's perfectly fine. It is within the limits. These shares will be locked in for 3 years. This is a very good retention tactic. Otherwise, what will happen? People will wait for sweat equity take and then leave the company. We don't want to do that. It is locked in means you cannot transfer the shares for at least 3 years. And this will be stamped prominently on the face of the certificate. We also need a valuation by a registered valuer who will tell us, who will justify the number of shares that you are giving against the consideration received. Disclosure in the board's report, and we will also maintain a register of sweat equity in form SH3. So these are basic requirements of sweat equity given to people who give us intellectual property, or they work hard for the organization but we don't have money to pay them, so instead we give them shares. Employee stock option. This is an employee retention tactic first started by Infosys in our country. So if I want to retain the employee, I will tell him that you stay in the company for 3 years, I will give you ESOP. Or now I don't have money to give you, I don't have salary to give you, it's a new company, and you must have seen on TV also, Shark Tank, that I don't have money now to pay you salary, or I will give you only 20,000 rupees salary, but I will give you ESOP. That is stock option. If I will give you shares instead, you will get appreciation, you will get dividend on that. So it is a retention that you stay in the organization. Or we'll tell him you work for 3 years, after 3 years you'll get ESOP, then if you stay for 5 years you will get more shares, if you stay for 7 years you'll get more shares. So that greed in the employees will help, will encourage them to stay in the organization only, and the talented pool will be in our company. Option is given because the word option is mentioned here. It is an option, it is not a compulsion. See, if the shares in the market are at 253 rupees, okay, the market value is 253 rupees. I am getting an option to buy the shares at 100 rupees. Of course, I will exercise. This is in the money. I will exercise. But if the price in the market is, let's say, 80 rupees, and the option at which I can buy is 100 rupees, I will never buy the shares. I will go and buy it in the open market. I will get it for cheap. So in this case, option is given to the employees to purchase or subscribe for the securities at a future date. It's an option, it's not a compulsion. We need approval of the shareholders by a special resolution, SEBI guidelines followed for listed companies. It is non-transferable. It is not, you cannot renounce it, you cannot transfer it to your friend who is interested. If you want, exercise that option or give it away. Minimum gap of 1 year between granting and vesting. It means today I have given you the stock option, you cannot immediately go and exercise it. You can do it in a year's time, so that you are again in the organization for 1 year. No benefits like bonus, dividend, voting rights will be given unless you exercise the option to purchase the shares. ESOP registered, maintain ESOP register, and you will also have to disclose it in the board's report. Okay, so we will maintain ESOP register, and disclosure will also be provided in the director's report. All right. Lastly, we have reduction of share capital. I have shares of face value 100 on which 75 rupees is paid up. I tell the shareholders, I don't need your money, don't give me 25 rupees which is outstanding. Now your shares are 75 fully paid. I'm reducing capital. Why does a company reduce capital? They don't need money. There is no requirement of money. Or it is an internal reconstruction. Subject to the confirmation of the tribunal. Okay, we need confirmation of the tribunal. Company can reduce the capital in the following ways. Now, what can be asked? Generally, procedure is asked, but for that you will also have to write the ways of reducing capital. by extinguishing or reducing the liability of members in respect of capital not paid up. The first example which I gave you, you're reducing their liability, don't pay the remaining 25 rupees, or paying off any capital on which is excess in need of the company. Company received shares of face value 100 was paid up, they returned, okay, they returned 25 rupees. In the first case, they had not received 25 rupees and they are saying, no, we don't want. In the second case, they had received and now they are returning. Or they are returning, they may say that we will call whenever required. Or they may return saying we don't need, we will never call it. Depends on the company. In both these cases, capital is reduced. You are cancelling or writing off any paid up capital which is not represented by assets of the company. Let's say that goodwill is worth 2 lakhs and there are preliminary expenses of 3 lakhs and shares are of let's say 10 lakh rupees. They are reducing the capital by 5 lakhs, and whatever 5 lakhs they are reducing, they are using it to write off the goodwill and preliminary expenses. Here the creditors are not worried because the money is remaining in the company only. We are using it to write off the goodwill and preliminary expenses. What is the procedure? You need authorization in the articles. Special resolution is required to be passed in the general meeting. This is first step. Step 2. Then you will apply to the tribunal. Tribunal will give a notice to the registrar, SEBI and others who are affected that see, we are reducing the capital. If you have any objection, please do so. They will make representation within 3 months. If there is no objection, then they will reduce it and they will require the company to publish that in the newspaper or any other manner like website. Copy of this order will also be delivered to the registrar. So students, these are steps which you have to learn and the chart book will help you to learn these concepts. So with this, we have quickly gone through the important provisions of shares and share capital. I hope you had a wonderful time in these few hours and you understood all the topics which were important, and it was a total brush up of all the important concepts for exam. This chart book will help you to learn the concepts because everything is written in point format. It is attractive as I already explained it to you. Best is that you keep this chart in front of you whenever you are revising the chapter so that there is a pictorial memory, you remember that in the exam. With this, we complete the part A of our video. In the next video, I will cover the remaining topics of Companies Act and we will also post for other laws. So don't feel that I'm going to just post Companies Act. We will post other laws also. With this, students, I would like to end the lecture here. You must be tired. Take a break. Go for a walk. If you have any doubt, you can contact me on the number given in the description box and also visit my website TheoryMastersLearning.com for books, lectures and test series. I'll see you in the next video. Till then, take care, students.